तो मतलब जब वहां जहाँ
Sound check. Check. One, two. Audio check.
Lord's permission, my lord, may I mention item 3, 22 and 23 on board, which is a Punjab counselling matters from yesterday. Today, my lord, the counselling is going
You
on.
want to take it up?
Yes, my lord. My lord, last day of counselling.
Don't be worried by the numbers. Just
My lords, may I make a mention in item number 247? I have filed my wakalatnama. May kindly permit me to file the physical appearance.
this is the
Tax effect matters.
Anybody who wants to file physical appearance in the tax matters, please do it.
Fine.
May I?
Yes, Mr.
There is an urgent review that's been filed and mentioning email to the effect has been sent with respect to my Lord's order of 2nd of August. This is with respect to a pharmaceutical matter. My Lord's has taken up another SLP despite the expiry of the patent and despite an injunction being granted. Whereas this different order has been passed in our case. Could my Lord's kindly consider that an application?
Review.
Please, my Lords, a review has been filed.
That will be circulated. That will be
An
circulated.
email to that effect has been moved, my Lords.
Sorry,
An email
that
is
will be
already
circulated.
Please
You'll
consider.
immediately, all reviews are listed immediately.
May I mention one matter, my Lords? With your Lordship's leave, my
Now,
Lords.
all that we'll go from here now. We'll go maintain some order. Anything which is capable of being mentioned in the email, please mention in an email. This is becoming a very bad practice, you know. People send an email at 12 o'clock in the night and say, but I have sent an email, and then come and mention in the morning.
That's the wrong, Your Lordship. That's the wrong, Your Lordship.
Why are you here?
Your Lordship, I'm just mentioning case, Your Lordship. MA, Your Lordship, that is a
MA. What?
MA.
Disposed of matter, MA. This is another fashion being in our
Lordship, that
by
is,
people who are not parties to the original proceeding. Were you a party to the original proceeding?
yes, Your Lordship, I'm a
What
party.
is the MA for?
MA is, Your Lordship, is for appeal of lodged matter, Your Lordship.
What is the MA for? I'll list them in.
Your Lordship, MA is lodged matter by registrar in writ petition, criminal writ
Because the
petition.
bench presided over by Justice Sanjeev Khanna has passed a final order. What MA now against a final order?
Lordship, that is the MA, Lordship, for publishing live law, Lordship, sexual harassment article, Lordship. For that, Lordship, for that purpose, Lordship, I filed the writ petition, Lordship.
He'll look at it, yes.
May I, my Lords?
Will you
With
apply?
your Lordship's leave, my Lords.
Mr. Sibal?
Master, that West Bengal reservation matter, there is huge urgency
Okay,
that
we'll list it.
we can't issue caste certificates.
It's listed.
It's listed 319, it will never reach.
Go by the numbers. The 319 is because of some of the tax matters. Just wait for 10 minutes and you'll see what will happen today.
Okay,
Lords,
But we have some matters, that ERA matter may take about 45 minutes.
but your lordships have the All India Judges matter also, therefore I'm a little concerned about
All right,
it.
but then we'll sort of give it a tweak and put it a little higher on board next week or something.
Yes, your lordships may have it tomorrow, day after, Can't get to admissions, can't.
Tomorrow's
Yes.
matters go to day after, so that the same board will continue. The idea is so that there is no matters I put into place.
Your lordships give some urgency. We can't issue caste certificates.
All right.
Deeply obliged.
my Lords, may I, with your Lordship's leave, my Lords, there's one matter I wanted to withdraw, my Lords. I've been writing emails, but it's not getting listed. I just want to withdraw it, my Lords. Simpliciter.
But look, yes.
I'm grateful.
I understand. I have written a mail and it's a genuine urgency. What High Court has done has asked for
It's a fresh matter.
Lordship, it's a fresh matter. I won't have troubled my laws. I know the
It will come up.
Lordship. No, the problem is the High Court says to the mother, please release the funds to her daughter by tomorrow. Otherwise, I'll haul you for contempt. The matter was
Funds for what? For the child's education.
that she's not a minor anymore. She's a major. But
But it will be listed. You want it tomorrow.
But-
What is the date of the High Court's order? Are you in this matter or some other matter?
Previous matter. Just Mr. Mukherjee mentioned that.
no,
Somebody comment. Are you aware of the etiquette in the court? It's not like you go to a shop. Acha, mujhe bhi ek VC goli do. Somebody is arguing a matter. She's on her legs. I'll hear her and then come back to you. Yes.
High Court passed the order on Friday. I filed an SLP yesterday because otherwise she'll be hauled for contempt tomorrow.
High Court passed the order yesterday.
No, on Friday.
Friday.
I took Saturday, Sunday. Unfortunately, High Court didn't take into consideration that it's a weekend. Much of
May I mention 31.5?
State petition, my Lord, it was listed yesterday before Justice Pardiwala's court, my Lord. Yeah.
Yesterday there was a little dislocation because Justice
Sorry, my Lord, I'm
Mishra was
not-
not well. Today, in fact, Justice Mishra is connected. There he is. He's connecting online.
Sorry, my Lord, I'm not complaining.
We'll list it tomorrow. It's before a bench of Justice Pardiwala and Justice Manoj Mishra. It's a detention matter.
Yes, my Lord.
What we'll do is, the three of us will rise a little early, like 15 minutes. And then my learned brothers will sit at about 3:45, hear you for 15 minutes and close it for judgment.
I'm so deeply obliged.
Brother Manoj, I think that we'll do tomorrow. You and Brother Jamshed.
Yes. Chief, I'll be available for.
So that then this detention matter, just inform Mr. Rohatgi is appearing.
Mr. Rohatgi, Mr. Luthra, I'll inform everybody.
All right, just tell them that, and this because yesterday brother was not well. And
I'm so obliged.
May I mention this matter? It's a fresh matter which was listed last Friday before Honorable Court number 4. It was directed to list today before Honorable Court number 3.
What the Registrar Judicial tells me that court has said that matter should be tagged. And the tag matter, the date is a little ahead, but he'll show me in the afternoon. I'll take a call in the evening.
The only issue is, the declaration form's last date is this Saturday.
Declaration for what?
This is concerning the Bar Association elections in High Court of Delhi and all the district courts. One of the conditions have already been stayed by the bench headed by...
Okay, I'll just see. Who, the main matter before Justice Suryakant or?
Before Justice Gawai. In fact, it was directed... If your lordship will, it was...
I'll have to go before Justice Gawai, but let me take a call in the evening. I'll post it appropriately.
Let's probably, if it can come today, because it was
Not
directed
today.
to be
I
listed.
mean, everybody is busy. Look at the kind of matters before benches today.
It was yesterday shown in the list, then deleted,
I'll distribute for Justice Gawai, but not today.
On.
It's 30, item 31.5, low tax effect matter. I am for SSC. As per our calculation, the tax effect is more than 5 crore. So
You are for the respondent.
for the SSC respondent, it should be more than 5 crore. It should not be in the list.
Oh, who's appearing for?
I just informed my friend.
I appear, Manoj. The entire 1 to 255 is direct tax matters. Manoj, we have
This is serial number
1 to 255. This is 31.5.
31.5.
But in addition, Manoj, we have about 66 matters which have to be saved. Even though it's 1 to 255, Manoj, the including combined matters, the list is much more. So, Manoj, apart from 66 matters, everything else can go.
So 66 matters have to be deleted from the list.
Including this would
This 31.5. You've got those 66 matters?
Manoj, may I send
Give them to just give them to the court master.
Yes.
So he'll make sure that those are removed from the list of matters on which we are passing orders today, including this 31.5.
Yes.
But make sure you send that to him, because by the evening the order will be uploaded.
Minutes,
Those 66, we would not know which 66.
It is wrongly put in.
No, it's very fair of you. Otherwise, the matter would have just gone with a general
Should not
order.
happen like that.
Yes.
About those 66, how do we know which are the 66? So they will be listed on some other day, sir?
Mr. Supergar, yes, those 66 matters will be relisted before the regular benches on another day. And you can perhaps, if any matter, Mr. Supergar, which matter are you appearing in?
Item 5.
5 is 5 in that or
5 is part of our list.
66.
66.
So, Mr. Supergar, 5 is part of the 66. So that will be delinked and then listed separately.
Lordship, I'm obliged.
Tax matter. Is 66, that numbers may be given in the order so that we all know which one has been excluded.
We can't give the excluded matters in the order. Which is your matter, tell him so that he will. All right, we will do this. The excluded matters, we will not put it in our judicial order. They'll be notified in the registry by the registry of the website. Something on we put in administrative circular.
Lordship, I am appearing in 17, item number 17, KRBL matter.
It's above, my lord. It's excluded.
That is excluded. It's excluded. It's above 5 crores.
No, only one of the three is above 5 crores.
According to our list, 17 is above the tax, my lord, so it has to be excluded.
Okay.
We've done that
As per
exercise
the-
yesterday.
So we'll notify those which are excluded as I said. But that he says is above 5 crores.
No, only one of the three.
If there is a problem, then that bench will look at it at that point of time. Yes.
Great.
What do you have to say?
Lordship, please.
This is in regard to the matter mentioned by Mr. Abhinav Mukherjee, Senior,
By?
Learned Senior Advocate Abhinav Mukherjee, sir. So I am appearing for the respondent number 14, Registrar of Companies. Our presence may be recorded.
Okay.
So great.
With your lordship's permission, may I mention a matter, your lordship? There was a civil appeal which was listed on the 2nd September and your lordship's order said it will be taken up on 24th, but your lordship, it's not listed today. And I'm facing a threat for disconnection, your lordship. I can't evacuate my power. That's the urgency in the matter.
It was mentioned yesterday. I've already given a date yesterday. I've already given a date. You'll get just check with the Registrar Judicial today. The date has been given.
Oblige, your lordship.
These are indirect tax matters.
On serial number 1 to 255 are the direct tax matters with low tax effect less than 5 crores. So in terms of the new circular of the Ministry of Finance, these matters will be disposed of, except for the excluded matters, which will be notified separately on the by a circular. So everybody, all the lawyers know which are the deleted matters. Then this is indirect taxes, right?
Yes.
This is for direct taxes. The circular of the Direct Tax Central Board of Direct Taxes is 17 September 2024.
Absolutely.
Yes, sir.
Not
Right?
Yes.
So then that's all. We'll
And indirect tax is 6th August 24.
that we have got.
Yes.
So serial number 1 to 255 we'll dispose of with one order.
Yes.
Then indirect taxes
256.
256 to 291 are the indirect tax matters with low tax effect. Those similarly we will dispose of.
My lord,
item
Just one second, let's hear what she's saying.
in item number 287 is the appeal in bill finder, where my lords is giving the directions for e-filing. But that is also a low value matter, and that will get disposed of in this list.
Oh,
I'm pointing that out. What I can submit is that is a group of 2 matters. So all those instructions can then be passed in the second matter. I will give the appeal number. Either way,
and the second matter is not low tax effect.
the second matter is not low tax.
Okay.
It is tagged on.
So in 287, you say that though the above matter is being disposed of on the ground of low tax effect,
Oh, my lords.
this court has been monitoring administrative aspects pertaining to the e-filing of matters by the revenue before diverse courts and tribunals across the country. Full stop. Since the above orders have been passed in the present matter, which has a tax effect of less than rupees 5 crores, it is clarified that this court would continue to monitor compliance with the earlier orders which have been passed in the present matter in regard to e-filing and other related issues in the companion appeal number so and so.
Give the civil appeal.
For convenience of reference, the registry may place a copy of the orders which have been passed in the present case with the companion appeal so as to facilitate monitoring by the appropriate bench.
My friend mentioned 66 cases, which he said consolidated, which is not party-wise consolidated. It is individual case has to be seen as per single item as well.
They are doing
Probably they
no, they are not giving a consolidated list. 66 cases will be notified separately, each one by party names.
That's what I want. So probably yes, that is consolidated effect is less than or more than 5 crore. Consolidated probably means to a
No.
Individual
cases.
Individual cases.
Yeah.
That is why last time I had requested
Individual cases, but they are saying that those cases which are above 5 crores will be notified separately by the court master, by the registrar judicial in an administrative circular, so that lawyers know.
47 is not there in 60.
I'll just verify that.
Why don't you all do this? After we rise, instead of asking across the court, you just talk to the learned counsel so he'll clarify straight away.
Yes.
and in the indirect tax matters, some of them are in a group where only particular matters are listed. So the orders may reflect the.
Yes, that will be reflected.
I'm obliged.
That we have.
We have also received.
Item 184 is the appeal by SSC one. So that.
So 184 has to be delinked. Huh? 184.
Yes, we'll add it to our list as
To add it to your list.
We have also received other requests, my lords, from other councils. We'll compile that list over the week and submit it, my lords, over the week. We'll do. Great.
And now, apart from this, how many are remaining now?
In everything is done, my lords, to our best knowledge, but some may remain here and
Then
there.
whatever remains, you just tell the registrar judicial ones, we list them.
Yes, grateful to you.
May I please, Lordship, I beg to appear for the 6 matters and for the respondent, Mr. Rajiv Nanda. Lordship, he has passed away. So in that case, the appeal.
On those appeals.
They have withdrawn the appeals.
Lordship,
They have withdrawn the
recorded
appeals.
the Lordships.
Sorry?
Let it be recorded that he passed away.
Why? If they are withdrawing the appeals. And he was a lawyer, right? He was a
Lordship, he is a respondent.
but anyway, they are withdrawing the appeals. What difference does it make now? They are withdrawing, the union is withdrawing the appeal. Assessee has passed away.
Please, Lordship, assessee.
So they are withdrawn.
They are withdrawing the appeal.
Obliged.
That everybody clears out the huge number of tax matters today.
I'm sorry, Millet. Item 28, Millet, I am withdrawing the appeal in this group, Millet. Item 28 is of the appellant.
Who are you for?
I am for the appellant. That is also.
No, you are. If you are withdrawing, you have to be for the appellant. But are you for the assessee or the revenue?
Assessee, Millet.
You want to withdraw your appeal.
I want to.
What is the name of the case?
Millet is the Pax Pin. Pax Pin, Commissioner of 8547 of 13. CA number 8547.
And you are the advocate on record? You are the advocate on
yes,
record?
Millet.
Just give it in writing to the court master. He'll pass.
Yes.
He'll record the order for withdrawal.
Because I got the letter also, I'll just give it to them.
Matters which we will take up before we start the regular part third matter. You want to call them out?
292? Yes, Well, this is a matter, my lords, where actually, my lords, two separate agreements and two separate parties and pertaining to two different properties. My lords, what had happened, my lords? One Hema Engineering, my lords, went into liquidation.
Hema Engineering.
Hema Engineering. The NCLT, my lords, Delhi passed an order liquidating my lord's company, and a liquidator was appointed. The liquidator, my lords, issued a public notice asking for our auction sale. The land and building, my lords, was purchased by one Parimal Enterprises. We are not concerned with that at the moment. The second, my lords, with regard to the machineries and equipments, there was a separate auction sale, and that was actually, my lords, purchased by, my lords, this Ajit, my lords, Industries. Now, I entered into a memorandum of understanding with these people to purchase, my lords, those machineries. Now, disputes arose, and I moved, my lords, an arbitration petition in so far as, my lords, these movables are concerned. The arbitrator, my lords, has been appointed, my lords. I have got no quarrel in so far as that petition is concerned.
Then?
In the meantime, my lords, with regard to the land and building, a Section 9 petition was moved asking that I should be restrained from alienating those property because I have entered into a memorandum of understanding with the auction purchaser. So therefore, in that Section 9 petition, my lords, an absolute injunction has been passed, whereas the prayer was only, my lords, with regard to I should not alienate the property. It was not in relation to, my lords, I should not enter the premises. The prayer was only for alienating the property.
Now, show us what is the order passed.
Yes, the common order has been passed. Where the mistake has occurred is...
Just show us.
Yes,
para 12, right? 10.
Yes, my lords.
Let's see where. Just read that para so far as the original application.
Yes, my lords. If my lords can kindly have, my lords. The improved order.
Yes, para 10.
Yes, my lords. Para 10, my lords. If my lords, actually, my lords, so far as 10 is concerned, so far as the original application 424, this is the Section 9 application.
Yes.
Filed by the applicant Mrs. KJ Engineering Forgings Limited. For injunction is concerned, the learned counsel for the applicant would submit that the applicant is successful purchaser of the property from NCLT. This is an error. They were not the original purchasers. The original purchasers was Parimal Industries, including for sale of immovable properties. On the other hand, the learned counsel for the respondent Quickstart Traders would submit that they are in possession of the machineries and other movable properties with them. However, this court is not able to believe the version of the respondent Quickstart Traders since the applicant has already taken possession of the immovable properties by virtue of the order passed by NCLT Delhi and the properties are with them. Therefore, the interim injunction already granted by this court, while order dated 9/7/24, is made absolute by making it clear that since the possession of the immovable properties rests with Adi Impact Services, again error. Adi, in fact, my lords, is not a purchaser so far as the land and property is concerned, building is concerned.
KJ forging.
Yeah, they are only for movables. Possession shall not be disturbed by the respondent at any cost. Then, my lords, the learned counsel for the. I am aggrieved by this portion of the order because.
Can you not file a review before the High Court and point this out? That
Well, I moved the division bench because since it's a composite order, section 9, I could not have gone before the division bench because of the prohibition under section 37. I actually apprised the division bench that look, I am confining my original suit appeal only in relation to section 9 application. But what the learned division bench did, since the facts are intervened, so therefore we will not, you please approach the Supreme Court. That's the order which the division bench has passed. That's how actually, my lords, I had to move this SLP. Kindly have the division bench order, my lords.
Where is that?
Yes, my lords. Kindly have it. Yes, in the additional documents, kindly at page 147, running page.
Additional documents?
No, my lords, in the SLP paper book, 147.
Annexure?
Annexure P17. Para 2.
Yes.
Immediate asset claim. Captioned OSA has been filed assailing a common order dated 11/7/24, made in section 11 arbitration original petition for the sake of brevity and convenience as well as in the section 9 application. Though captioned as OSA is qua section 9, application as impugned order is a common order and issues are dovetailed and inextricably intertwined. It is really not possible to jettison the section 9 part of the order. To put it differently, it is not possible to test the section 9 order without testing the section 11 also, which is completely erroneous because section 11 I am not at all aggrieved.
Appointment of the arbitrator, you are not.
I am not aggrieved. I have said so in my SLP as well as I have given a letter also to the registry that I am not concerned with section 11.
And section 9, no 37 appeal would lie.
Yes, no 37 would have. 37. Therefore, I had to, my lords, in so far as section 9 is concerned, I can go before the division bench.
But the division bench declines to entertain. 11, you will have to come here.
11, I have to come here, and therefore, since the facts are intervened, I cannot actually move the division bench. That's how the directions have been given.
But Mr. Basudevan, yes. Can you not go back to the division bench in a review and point this out to them? Yeah. If there are factual errors,
yes, my lord.
The appropriate thing is that the judges have made an obvious factual error. Point it out to them that there is.
My lords, I have got no difficulty at all. I will go back in the 9 because the injunction was only to a limited purpose of not alienating your property. I have got no problem at all. I will in fact.
Your statement that since there are factual errors in the impugned order.
Yes, madam.
You have advised the client that that you can move the High Court for correction of those errors instead of us issuing notice, continuing with this endlessly. Brother Mishra, do you think that the better thing is to allow them to do that? These are small issues in the High Court.
Problem today, what has come is there are two different my lords contracts, one for movables and another for land and property. Now I am actually virtually being pushed out of both the things because of the restraint order. My lords may clarify this. My lords may clarify this restraint.
After arguing the special petition for a short while, Mr. R. Balasubramaniam, then senior counsel, requests this court to allow the petitioner to withdraw the special petition in order to enable them to move the High Court in the exercise of its review jurisdiction. It being the case of the petitioner that there are certain inadvertent errors in the factual narration in the impugned order.
Yes, sir.
Full stop. We accordingly dispose of the petition as withdrawn with liberty to the petitioners to pursue proceedings and review. However, it is clarified that we have not expressed any opinion on the merits of the submissions which may be dealt with by the High Court.
Yes, my lords, only one small indulgence, my lords. I will move the division bench because the division bench throws me out.
That's why we have said you want to move the division bench.
Division bench on the my lords original appeal. On the my lords the original suit appeal. I want actually to move the division because the division bench.
You'll say against the order of the division bench.
Yes,
to August 2024.
Yes, I will actually move
whatever you think. Because we are allowing you to do that, if you feel that you are better off going to the division bench,
Yes,
because those are where the errors took place.
The problem has come. Yes, my lord.
We'll permit you to do that.
Yes, my lord.
Let me do that. Yeah.
Yes, my lords may kindly clarify.
All right.
Oblige, my lord. My lords, one more small indulgence, my lord. Their main prayer, my lords, in the Section 9 petition was only with regard that I should not alienate the property. That may be, my lords, my submission may be recorded, so that tomorrow, my lords, they are not permitting me to enter the property even to collect the movables. That other petition.
You just say Mr. R. Balasubramanian, Learned Senior Counsel, has submitted that though the prayers, the petition under Section 9 were only in respect of
not to alienate the land and building,
were only in respect of the alienation of the land, the relief which has been granted is in much wider terms.
Yes, ma'am.
And then we'll give liberty to.
Yes, yes, ma'am.
Yes.
This
Item number
293, my lords.
Tell us what is it about.
My lords, it's an unfortunate case, my lords, where the petitioner, my lords, who is a son of a daily wager, my lord, belonging to the scheduled caste category, my lords, on the basis of his ranking, he was granted admission to IIT Dhanbad. My lords, the fees for that was 17,500. And my lords, they could arrange only on the last day of submission. So my lords, he logged in on the last day.
The portal didn't open.
My lords, he uploaded the documents, but when the time of paying the fees came, my lords, that time was over, so he was logged out of the system, my lords. So immediately at
what is the last date?
My lords, the last date was 24th of June 2024 at 5 o'clock.
Didn't it come earlier?
My lords, what
you've done something right away for your client.
Yes, my lord. What happened was that, my lord, because he had got admission in Dhanbad, my lords, he approached the legal aid in Jharkhand High Court. My lords, there he was advised that he should go to Chennai because the entire examination was conducted by IIT Madras.
Okay.
So he went to Chennai High Court, my lords. There again he was advised that the kind of relief which is being sought, it cannot be granted under 226. So he withdrew, and my lords, we immediately approached. In fact, my lords, he went to the legal aid of the Honorable Supreme Court also. But there was some time which they said, so he, my lords, approached me, and my lords, we have immediately filed the petition.
Strictly, where is the child? Where is he?
He is from
Muzaffarnagar.
Muzaffarnagar, UP, my lords. So because he had got admission in IIT Dhanbad, my lords, he first approached. My lords, and he had got.
You had come a little earlier, but we'll try and see what Brother Mishra. I think we'll try and work out something for him.
Because he has a very
the petitioner who resides in Muzaffarnagar in Uttar Pradesh is a son of a daily wager. He was allotted a seat at IIT Dhanbad. His grievance is that by the time that he could arrange funds in the amount of rupees 17,500 towards his admission fees, he was logged out of the system, should we say?
Well, he had uploaded the document.
He was able to upload the documents, but eventually was unable to pay the fees online due to a technical glitch.
But the time was only till 5 o'clock. So
since the time had expired at 5 p.m. Yeah. Since the cutoff was at 5 p.m. on
24/6/24.
On 24 June 2024. So it appears that thereafter the petitioner made an effort to contact the Legal Services Authority in the state of Jharkhand, but was directed to move the competent court in Chennai. Since the examination is conducted by the IIT Madras. However, eventually he was apprised of the fact that the reliefs which have been sought would not be amenable to the jurisdiction under Article 226 of the Constitution. So, bearing in mind the social background of the petitioner and the hardship which he has undergone, we are of the view that this is a fit and proper case for the issuance of notice to explore if something can be done for protecting the admission of the petitioner. So, issue notice returnable on. We'll keep it today, Tuesday. We'll keep it on Friday, Monday, next Monday.
My lords, I'll serve Dasti to the respondents.
Dasti, on the request of the Learned Council, Dasti permitted in addition. Just see, I think they have a standing council over here.
I'll serve the standing council as well.
And just talk to him. So
I'll do that.
See what we can.
Because unfortunately, it is his second attempt, so it's a last attempt, so he cannot
it's last attempt. So even if he fails this because he's joining late, it's better because he'll at least get his admission. We'll see what we can do. We'll help you.
I'm grateful.
But now the only problem is classes have begun 3 months ago. Anyway, we'll see. We'll see what we can do. 290?
320?
Yes. 320. Yes.
I am appealing for the respondents. I am appealing for the caveator, but we were the parties to in the division bench in the Calcutta High Court, but we have not made parties here.
And you are directly affected.
I am directly affected. These matters are pending for 2016. We are the successful candidate. First round litigation was there, then the entire selection process was set aside. Then the second round litigation, ultimately the learned single judge was directed to put the grievances before a mechanism was set up and to put their grievance. Against that order, they forward appeal to the division bench. In the division bench, when matter was pending for 2 or 3 years, then we entered. Then and these petitioners were not the main read petitioners in the before the Calcutta High Court.
But I am appearing for the appellant, my lord.
Yes.
I am appearing for the appellant, my lord. My only grievances are, my lord, that persons have been accommodated, my lord, contrary to the cut-off marks. Not the cut-off marks, assuming it is 75, my lord, persons, my lord, have been accommodated. My lord, I have got more marks. I have not been called for the interview.
That is the issue with my application as well, Malats. That's the application, my application as well. Same grievance, Malats.
Who are you actually? You are an intervener.
Please, no, Malats, I am one of the Malats persons who had appeared, Malats, in the examination, the earlier Malats.
But you are today here as an intervener.
Please, Malats.
What do you have to say about this, that you have got less than the cutoff marks and yet you have been admitted?
No, this is not correct. The entire thing haven't gone. Can I just?
Yes.
What has happened in the earlier litigation, one of the learned single judge set aside the entire selection process and asked to start it from the stage under Rule 2 and Sub-Rule 2. The interview and the director circling the directions. Now, the persons who were interviewed, these petitioners were not within that.
Malas, mine is an SLP, Malas. My apologies. Mine is an SLP, Malas.
Is it on board today?
Malas, it's on board. It's on board.
No.
SLP hai kya?
It's on board today. No?
Your SLP is not on board. That's why we didn't see it. That's the problem.
It's not 20.
My SLP is them.
It doesn't appear to be on board. So we'll just wait. Let's wait and finish this matter.
My learned senior, Mr. Bandopadhyay, was appearing before the Honorable High Court also. He was appearing for the successful persons. My only grievance is, persons have been, accommodated, who have got lesser marks. As against me, assuming, the appellant.
How does the High Court deal with this grievance of yours?
But the Honorable High Court, unfortunately, has not dealt with this issue, assuming, Rakibuddin Mondo, the appellant number 1.
Issue has not been dealt.
Did you appear before the High Court?
As an intervener, we had taken out independent applications in connection with the appeal.
Somebody just, something is not raised before the High Court. And now we'll have to, if you are right, we'll have to reopen all this. You file a review before the High Court.
With greatest of respect to my lord, with greatest of respect to my lords, kindly.
What is this grievance that the Learned Council is making, that people who had marks below the cutoff marks have been accommodated by the... Now we don't find that this was even argued before the High Court.
May I just...
Yes,
just permit me. Firstly, Milord, kindly see, they were not the writ petitioners, number 1.
These are all interveners.
Intervener. Second is this, Milord, that was our argument which has been accepted. What has happened, Milord, in the main writ petition, what the case was made out and the pleading was there, that was, Milord, gone because of the learned single judge order mechanism has been fixed, Milord, all the grievances. before the appeal court, they made certain submissions from the bar. From the bar. Not the pleading has been amended.
And they were not petitioners also before the
Not the High Court.
This will be
intervened as well.
Just one second, I just stop it, since brother is on.
Appellate is made clear. This is that there are two other SLPs which are appearing along with
the Millet. Brother Mishra, I'll just try.
Has this been filed, SLP? This has been, no, not been filed. SLP, huh? SLP नाम आ रहा नहीं, SLP आ रहा नहीं. This is not before this is not listed today. This SLP is not listed.
Listed.
It's not
choose for peace.
Show me from the first list.
I can't hear you. No, I'm unable to hear your lordship.
See, the problem with these people is that they were interveners before the High Court. You did not follow any substantive remedy of your own. You argue something which you said has not been noticed by the High Court.
Kindly seize me not paragraph.
How can we unsettle the whole process now?
So far I am concerned, my petition is 320 in the supplementary list.
It's not even on board today.
It's board, it's in the board, 320 supplementary list.
We'll deal with this.
Please,
first.
Please, Malaz.
One just line.
320 supplementary list.
Can I just one line, one sentence?
Hello.
Page 25 of the judgment. Just similar page 25 of the judgment. When the matter was directed to appear, even when the appeal was papered, appeal court directed them to SSC to decide the disputes which have been raised by them. Kindly see, the court was apprised that upon consideration of the represent, the commission had found 1585 candidates to be genuine and they are allowed to upload their documents. That was the 1585 persons who had really the grievance. The commission has come to the finding their grievances are genuine. They have been included. But these persons, yes.
No, that's not the outcome. The outcome is
later on. Please, yes.
What is the outcome, Mr.
Look, the outcome is that out of a batch of 14,000 odd, the commission had had done a re-evaluation. On that re-evaluation, they had said that about 1,400. Initially, they said 1,400. Later, then they said 700. We are saying should not be in the list. But Millard, now the order is that you cannot re-evaluate at all. You go by the original merit list. To that extent, Millard, the court has allowed it. So 14,000 odd, Millard, will have to be taken into account in this case. Now, as far as Millard, those persons who regarding whom even the commission has some doubt, Millard, it can be there are enough vacancies for the future. So therefore, Millard, if your lordship wishes, Millard, that those vacancies can be kept aside also. But only thing is, Millard, that the 2016 tech batch, which is, Millard, actually the source of a lot of litigation, there have been no appointments since then, Millard. So therefore, Millard, the commission feels, Millard, that some progress has to be made in making appointments.
Finality here will actually allow the appointments to be made.
Yes, exactly.
Malaz, I'm appearing for 15 people, Malaz. All of them have got more than the cut-off marks, Malaz.
Now, same goes for me, Milord. My candidates have also
39
more than the cut-off marks.
39, yes, my lord.
Yes, my lord. Before that, 38, your lordship sees, my lord, then the point will become clear.
Paragraph 39 and 40 upon such re-evaluation.
My lord, kindly see 38 first, my lord, because that will make it clear. Top of the page 46. Yes. Mr. Mukherjee, learned senior advocate appearing for the commission has, however, not been able to justify the act of the commission towards rechecking of the documents of candidates who appeared in the personality test, 14,052 candidates, after completion of interviews as stated in the supplementary affidavit dated such and such. Then 39. Upon such re-evaluation, initially 1463, that consists of, my lord, two mismatch of class category, 559 mismatch of marks, and 902 for defaced OMR sheets were excluded. Upon further revision and perusal of records of 902, 750 candidates were brought within the zone of consideration. Accordingly, 1463 minus 750, 713 were ultimately excluded. Such exclusion is not sustainable in law, and consequently the said candidates also come within the zone of consideration. As there is a total of 14,339 vacancies, there cannot be any hindrance towards inclusion of all the candidates called for PT, being personality test, PT, being 14,052 candidates in the merit list as against 14,339.
So now the High Court has told you to publish the final merit list for 14,052 candidates.
That's correct.
You are not aggrieved by this?
No, my lord, we have not preferred any appeal.
Right.
Though it is our contention, my lord, that some of them now, there is some difficulty.
Are they included in the 14,052?
Yes, everybody is included.
No. Are you in the 14,052?
No, my lords. My instruction is no, my lords.
Then that means, my lord, that they did not survive the personality test.
We will dismiss the SLP by the intervener, because we don't want to now, somebody who intervenes in the High Court should not be given the right of an audience here.
Not true.
Otherwise, this will be an endless process.
Yes.
Insofar as his SLP is concerned, can you give a copy of your SLP to Mr. Gupta and Mr. Bhattacharya also?
As well as Malaz, the statement of marks which shows Malaz, we are above
the... Millard, the TET marks is not the end of the story, Millard. After that, there is a personality test.
Right. Now, what about these people?
These people, Millard, must not have cleared the personality test. Probably. I will look into it.
Can you just verify what is this category?
Because we were not called for the
personality
test. Without the personality test, Malaz, we are above the cutoff, Malaz.
No, they are not.
Academic and professional qualification, we are above the cutoff marks.
They are not called in the interview. They are not called in the interview even.
Persons below us have been called. Persons below us have been called.
Let the state examine and come back.
Did you go?
No. Malas, we were interveners before the High Court.
Oh, then you never followed your original. Yes. Then you are out. You are interveners before.
All of us were permitted to file applications before the Honorable High Court. All of us were permitted to file applications before the Honorable High Court in connection with the principal appeal.
Filing an independent.
Malas, above the cutoff marks, Malas.
No, we now have clarity so far as you are concerned also. You are interveners before the High Court. You are now seeking to say that, well, we had more than the cutoff marks. You should have filed an independent petition before the High Court. How can you come here for the first time against the judgment of the High Court? So we'll dismiss both matters. Brother Mishra?
Yes. Ultimately, the direction is only to follow the rules.
Right.
Yes, we had a writ petition, but interveners before the appellate court.
Please give the SLP number. So we'll start it.
022207 of 24.
Just write it down. There's somebody else's SLP.
I'll give it to the court.
For the High Court in a similar matter, I have filed the SLP, my lord.
We'll deal with it when it comes up. We'll let your SLP be listed. You will take it up.
I have made my submission before the High Court.
We'll list your SLP. Today it's not on board. Give a copy to Mr. Gupta and Mr. Bhattacharya and learn counsel of the commission, so that then we will hear it. But we'll not take a matter which we have not read. We don't have the benefit of assistance by the learned counsel on the other side.
From paragraph 14, I made my submission before the.
Let your SLP be on board. It's not even on board.
After long years, rather almost we are reaching into a decade, the Calcutta High Court has cleared appointments. This is the most strange thing, Lord. All appointments are set aside. All appointments are bad. All appointments. After long years, at least these persons will get some appointment.
That's why
only minor.
Trying to interfere. We took a slightly technical view that the interveners will not come here because let some
appointments. Minors will kindly keep the option of kindly permit us to.
Vacancies are drawing.
Minors kindly permit us to approach the Honorable High Court if we are so advised. Kindly leave that option open.
All right. Now, any
do we have
keep the question.
Our matter is not on board. 2207 not on board.
Any other SLPs which are not on board, we'll bring them on board and deal with them so that we have also read it. Other side has also read those matters.
So far as item number.
And
You can give your appearance. Mr. Bandyopadhyay, Mr. Gupta, all of you give your appearances to the court master so that
We have already my senior has been appearing on PC. Wishes to make sense sufficiency.
Which matter?
320 Malats. Just
320 is over now.
Yeah. Please. Deeply obliged, Malats. Grateful.
Please, Lord.
Yes.
But in this case, kindly see the issue is what is the definition of NRI, my lord? Lordship has already decided in a case which is pending here.
Board yesterday, right?
Well, that's the matter. 323, Your Lordship. We'll have the brief of 323, please. Well, that's the Punjab matter, which was listed.
Which matter do we take? Do we take the Punjab matter?
Punjab 323. Kindly take that.
Well, I'm in 322. Mine was also an SLP file.
Yes, sir.
That was serial number what yesterday, by the way?
Because yesterday it was serial number 38, 3, my lords. 33. 33.
Sorry.
Yesterday.
Just give us one moment.
Yes, my lords.
Well, 33 था ना?
NRI, NRI. Correct, same here. Yes, my lords will have page 50. What has happened is there is a narrow definition of NRI and there is a definition of what is called a ward. So children is one, that's the obvious category. And then there's a ward.
You are appearing for the respondent.
I'm appearing for the respondents. Allow me to. Yes.
I'm appearing for the respondent, Malad, who are supporting
They are
the
supporting
state
us.
of Punjab.
All right.
So, Malad.
And I have only to show 3 orders of your lordship, Malad, where?
Lord, I'm for the
Shazam Farasad is for the state of Punjab.
For the candidates who, Malad, who are the beneficiaries of the second notification corrigendum.
And you are the original petitioner.
Yeah, the original petitioner.
My lord, I'm appearing on behalf of the university in the matter, Malad, in both the matters.
All right.
Well, I'm for the interview.
May I just say one thing? So far, I am concerned. I am saying that the real brother and sister should be treated as for the purpose of NRI, and the real brother sister may.
We provided it.
Malad will have page 51.
And central government has already issued order.
Already there, sir. Real brother and sister, there's no difficulty.
No, that is the problem.
You will add to the confusion. Let Mr. Farasat argue the matter. So we'll see what the matter is. All right.
Malad will have page 51. Malad, so there are 2 categories: the children, NRI himself or herself, or children, and the ward. Now, Malad, the ward is the expanded criteria. Malad, the first question that day which fell from the court is, how have you used this criteria? We have, Malad, followed your lordship's judgment of 2017. That's what I'm showing first. Page 51. And my lords will have
51 PDF.
My lords, PDF will be 72. 72 PDF.
Yes.
Yes. My lords, this is consortium of deemed universities in Karnataka. This is a judgment which has been relied upon by every other state and also the union. They are also following this logic.
Yeah.
Now, my lords will have page 52, PDF 73. The matter was listed today for consideration of filling up of the NRI quota. I'm not going to go into it. Just PA Inamdar is quoted, my lords. That's the main judgment which is followed. I'll just read it. Here itself, we are inclined to deal with the question as to seats allocated for NRI or NRI seats. It is common knowledge that some of the institutions grant admission to a certain number of students under such quota by charging a higher amount of fee. In fact, the term NRI in relation to admissions is a misnomer. By and large, we have noticed in cases after cases coming to this court, neither the students who get admission under the category nor their parents are NRIs. In effect and reality, under this category, less meritorious students but who can afford to bring more money get admission. During the course of the hearing, it was pointed out that a limited number of such seats should be made available, as the money brought in by such students admitted against NRI quota enables the educational institutions to strengthen their level of education and also to enlarge the people of Indian education activities. It was also pointed out people of Indian origin who have migrated to other countries have a desire to bring back the children to their own country, as they are not only getting good education but also get reunited with Indian cultural ethos, etc. They also wish the money which they would be spending elsewhere on education of their children should rather reach their own motherland. A limited reservation of such seats not exceeding 15% in our opinion may be made available to NRIs depending on the discretion of the management, subject to the 2 conditions. First, such seats should be utilized bona fide by the NRIs and only for their children or wards. Well, let's just underline because this has been interpreted later on, or wards. Secondly, within this quota, the merit should not be given a complete go by. The amount of money in whatever form collected from such NRIs should be utilized for benefiting students such as from economically weaker sections of the society who are on well-defined criteria the educational institutions may admit on subsidized payment of their fee. Now, my lords, the submission. Submission of the learned senior counsel is that the word wards used in the said paragraph should be understood in a broader compass and may be applied in a broader spectrum. He has also drawn our attention to the decision rendered in Ruchin Bharat Patel. And this is earlier Supreme Court decision only. Now your lordships will have in this para 1. Normally the admission to medical colleges should have been finally concluded before 30th September. This year's admission is long overdue, and if this 15% of the students are not allowed to be admitted under NRI, maybe financial loss to colleges, seats will go waste. In view of the peculiar circumstances of the case, for this year we are taking a practical view of the situation, and we feel that the students of these colleges may be admitted under the following direction. Now kindly have page 54. Just
1, 2, 3. That is the expanded.
The students be admitted as NRIs in NRI quota as against 15%. At least one of the parents of such students should be an NRI and shall ordinarily be residing abroad. That's the second. I'm coming to that, sir. Just 1 second. Yes, I'm coming to that. So first is one of the standard criteria. Now your lordships will come at page 54. This is the person who sponsors the student for admission should be a first degree relation of the student and should be ordinarily residing abroad as an NRI. If the student has no
by first degree relation.
That's I'm so grateful. Now that is your lordship has been defined in Anshul Tomar, which is
anyway, we'll just read the whole.
Yes. If the student has no parents or near relatives or taken as a ward by some other nearest relative, such students also may be considered for admission provided the guardian has bona fide treated the students as a ward, and such guardian shall file an affidavit indicating the interest shown in the affairs of the student and also his relationship with the student and such person, and also should be an NRI. Even if these parameters are applied and sufficient number of students are not available for this year, as against the admission to 15% quota, the colleges would be at liberty to fill up the remaining seats from the state list. And if the number of candidates admitted as against 15% quota is very much less and the colleges are unable to raise sufficient funds, they would be at the liberty to approach the committee to restructure the fee. In this regard, our attention has been invited to a division bench decision of the High Court of MP in Anshul Tomar. And my lords, here I will just read. Your lordships will have over the page 55. Serial number 3. My lords have that? Well, that answers my lord the Chief Justice's question.
Serial 2 also, please. Serial 2 also.
Read from serial 2 as well. If the first degree relation of the student is NRI and residing abroad ordinarily, then in such circumstances also qua this year should be considered eligible. Well, there is no difficulty on that. That's the obvious category. Now, as
brother and sisters,
it is natural that such definition would include the real brother and sister over the above mother, father of the first degree relation.
This is the issue in my case.
That's all. Now kindly have 3 more. 3 is the issue in our case. 3 onwards. As per the definition revised by the Honorable Apex Court, interpretation of clause 3 therefore as not made limited, but if made in a broad perspective, then it is clear that the person who wanted to consider such student as ward, Palya, then he be considered to be proper subject to compliance of the following conditions. Now, he should be a nearest relation. In the definition of the nearest relation, committee has considered the following relatives having blood relations: real brother and sister of father, that is real uncle and aunt; real brother and sister of mother, real maternal uncle and maternal aunt; father and mother of father, that is grandfather and grandmother; father and mother of mother, that is maternal grandfather and maternal grandmother; first degree paternal and maternal cousins. Such persons should be NRI, that is the aunt, uncle, etc. should be NRI. Such person should be ordinarily be residing abroad. Such person should have looked after such student as the guardian of the student, and the evidence to that effect must have been produced before the committee by such person. There should be an affidavit with aforesaid fact.
This was an interlocutory order of.
That's correct. But Mullah, just one.
Now what have you done?
So what we have done is, Mullah, the initial category.
Let him finish.
Mullah, the initial category, we initiated the process of expanding the definition historically.
Now what is the original definition and the expanded definition?
Original definition was NRI and NRI children. And the expanded definition was what I have just read to your lordships of nearest relation.
Now show us the original definition and the expanded definition. Let's see. Let's put paper to the eyes.
Yes, my lords. Your lordships will straight away have page 68.
PDF, please.
Yes, my lords. 89.
89.
Yes. No, this is the original.
88. You are referring to the corrigendum, right?
Yes, my lords.
That was the subject matter of challenge.
Yes.
No, Mulas, I'm first referring to the original definition.
Original.
And then I'll come
Where is the original definition?
at PDF page 89.
That is printed page
68.
68.
Your pages do not tell you.
Because your lordships are having 323 or.
So 68 is 84 PDF accordingly.
This is the notification of 9th of August.
That's correct. That is correct.
All right, just 1 second. That begins at page 74. The notification is of 9th August 24.
Plus internal page 11 of that document.
All right, we just go to that.
17, clause 17.
That's right. I'm grateful.
Correct?
Yes, that's right.
Non-resident.
Plus non-resident Indian NRI seats, 15% seats in all private institutes.
Got it. Non-resident NRI seats. Yes, 15%.
In all private institutes, Guru Gobind Singh Medical College, Faridkot, and 13 seats in each government medical college, Patiala and Amritsar, and 3 seats in government dental college, Amritsar, and 4 seats in government dental college, Patiala, shall be earmarked for non-residents Indian in the following order. Category 1, NRI children of NRI who originally belong to the state of Punjab, NRI children of NRI who originally belong to an Indian state other than Punjab. This is the original category. Well, this is of 9th August. This, my lords, is amended as of 20th August. Because in fact, I have it in the form of a chart. If you lordships want, I can place it. I've compared it exactly.
Okay. But Brother Mishra is not there, so you can just go to the.
That's correct.
No, I'm. What is the next?
Yes.
Where is the amended definition?
Page, my lords, 72, PDF 93.
No, 88.
There's some.
88.
Yes.
The amendment is 20th of August. Now,
my lords, this on the right side is the modified. This is exactly what I read from the interim order. For admission under the NRI quota,
actual NRI candidates.
Correct. Actual NRI candidates who originally belong to state of Punjab, children of NRIs who originally belong to Punjab state, actual NRIs who originally belong to an Indian state or union territory other than Punjab, children of NRIs who originally belong to an Indian state or union territories other than Punjab. In case of seat of NRIs are left vacant, after considering the above preference A to D, then the candidates whose ward/nearest relation to NRI shall be also be considered under the NRI.
What do you mean by ward, nearest relation? It's all so vague.
No, they answer that. They answer that.
Nearest relation for me may be the third cousin. For
What
somebody else may be the
defined.
No,
it is so subjective.
Just read out.
No, that's an interim order of support.
That is correct, Mullah, but what we have done.
Fraud.
Once it
Lord, your lordship.
What do you mean by nearest relation?
I told your lordship.
Can I answer?
The central government has adopted the definition. It's
1 second. Let Mr. Farasat argue.
Don't form.
All right, 1 second. Let Mr. Farasat argue.
Yes, Mullah. First, to answer the court's question.
He shall be, now complete reading.
Yes.
He shall be the nearest
relation. In the definition of nearest relation, following relation having blood relations will be considered. Real brother and sister of father, that is real uncle and aunt. Real brother and sister of mother, that is real maternal uncle and maternal aunt. Father and mother of father, that is grandfather and grandmother. Father and mother of mother, that is maternal grandfather and maternal grandmother. First degree paternal and maternal cousins. Such person should be NRI. Such person should ordinarily be residing abroad. Now, this is also important. 4. Such person should have looked after such student as the guardian of the student, and evidence to that effect must have been produced before the committee by such person in the form of an affidavit duly verified by the competent authority. Just one thing. Now, today the situation is this. This is in state of Punjab. Himachal. Today the situation is this. This is only in the state of Punjab, Himachal, Rajasthan, UP of Chandigarh,
all central
and central government. Everybody is following this definition which I introduced. Everybody. So today the situation is I am being restricted to the narrow definition and everybody else is on a larger definition. I have a potential solution. Given some counselling has happened, I'll place it before the court if it meets with the court's approval. Because counselling has happened, it should satisfy everybody. What proposal I'm putting to the court.
But look at this, look at your kind of expansion. You say
No, that's what
candidates who is the ward nearest relation.
Well, that your lordship will have to decide finally.
And nearest relation of NRI shall also be considered. And that clarification applies to nearest relation, not a ward. Ward means what?
Correct.
Anybody is a ward of anybody.
This is defined.
This is nothing. I tell you what, this is just nothing but a money spinning device by the state. That's all.
But well, the court has recognized that.
Don't
lordships.
Don't
Because
accept
the beauty of this definition is
thereafter.
One second, Mr. Singh will hear you out.
Plus today what has happened is counseling for first round is over. Plus the total number of seats, and I'll place this. It should, for the moment, as an interim measure, possibly, it will, your lordships will consider this. Just have this for a moment. Sorry, I can't place it before Justice Mishra. I'll read it out aloud. Give copies to the outside. Plus, first round of counseling is over. Just have page 1 first of this.
You see, 2 paragraphs of the order of the Chief Justice, para 3.22 and para 3.23. They
The problem with this definition is anybody can file an affidavit and say I have an NRI relative.
because it says ward means I have looked after somebody. And when an affidavit is filed, evidence means what? An affidavit is produced and he becomes a ward.
Plus that will lordship have to
Nothing. And you know what this does is, this deprives qualified GC candidates, general category candidates who would otherwise get these seats.
In these facts, it doesn't.
And this is just opening up, I tell you, this is opening up a whole avenue for nothing but misuse.
Well, may I submit in these facts? I'm grateful for my lord's observation, but in these facts, it does not impact that. That's what I'm placing before the court. Kindly have that note I've placed just for a moment. There's huge disparity between marks.
15% seats means how many seats, Mr. Faras?
That's right. So total seats are 168. NRI seats.
So 15% will constitute how many?
Plus NRI seats is 15%, that is 168.
168?
Yes, correct.
In the entire state?
In the entire state, private and public colleges, both.
So your argument is that if all these seats are not filled up and some of the seats remain vacant, then you apply the expanded definition.
Yes.
And that is how you
yes, and I will still not be able to fill up seats. That's the submission I'm making, and seats will still go to the general, and whatever the 16 respondents, whatever they want, they will still get that. That's my submission. Your lordships will just have a note for a moment. For a moment. Just have.
Here, Mr.
Just permit me 2 minutes.
May I just make one submission?
All right.
I have placed a small compilation. The orders passed by this.
I tell you, we must now stop this NRI quota business.
Let me
It's completely a fraud, I tell you.
May I change it?
And ward means what? You say that I have looked after this child. How do you produce evidence? Somebody will file an affidavit. This is what are we doing to our education system? And no wonder the Punjab and Haryana High Court has written a very candid and
my case is entirely different.
That is know what they are dealing with, and we discuss the.
I'll take only 1 minute.
First order. May I just take
1 second, sir.
First order. Justice Shilnagu and Justice Kshetrapal have dealt with the matter threadbare and dealt with it correctly.
May I make one submission for your lordship's consideration?
In India.
Well, these are all Indian residents.
Exactly.
Most of
So
them.
they all are residing in India, and by virtue of the fact that the parents of mama, mummy, kaka, kaki, all are there, who are,
That will be true for some of the NRI in the original category also, they may be residing in India.
and also those who are taking care of them, directly, indirectly, there is no end to it.
I would just say this, your lordships have to finally decide this issue, that order I was showing, your lordship said the final issue, which is the correct definition, is pending.
We will affirm the judgment of the High Court. Yes.
Lord, can I just make one?
That's 3 points I wanted to
One second.
Yes, let Mr. Maninder Singh.
Malad, your lordship will just keep one thing in this mind, Malad, and your lordship formulated it. It is formulated pan-India basis, accepted by the central government. Just have a look, Malad, it's a PDF also, but for your lordship convenience, Malad, this. After what, Malad, my learned friend did, what are the order passed by this honorable court? Just kindly come to that, Malad. Malad, the order which my learned friend has shown to your lordship, Lord Honorable the Chief may just have it, my lord.
Yes.
Let's just have a look at that. The order which my learned friend has shown to your lordships, my lord, is at page 8 of this small compilation. I'll respond to your lordship, lord. Your lordship's query.
Just one question has come to my mind. Any cutoff so far as percentage is concerned?
Yes, sir, they all appear in need, and need cutoff is to be followed by them.
So, Malad,
there is no relaxation in that.
Just a minute. He is appearing for the state.
Malad, there are 16 petitioners before the High Court who are respondents here. Malad, insofar as 5 are concerned, if I release all the seats, because I don't follow the expanded criteria, those 5 will get it. If I release the seats after accommodating the category, expanded category, those 5 will still get in with the exact same colleges. That was my submission.
Whatever is their fate is their fate. But we shouldn't allow this fraud. We should not allow.
May I just make one submission for your lordship consideration?
Just have a look at this, my lord, page 8, which is an order, my lord, in Ruchin Bharat, which your lordship passed. Just have a look at page 8. Same as PDF, sir. It's already circulated.
It's a one-time arrangement.
No, Lord, it's not.
Peculiar circumstances, they say.
Just have a look at that. Your lordship continued it. It is made to be adopted by the central government. Kindly see that, my lord. My lord, at page 8 with the judgment.
But
your lordship will permit me to just show it, my lord. This impression has to go, my lord. Yes. Kindly see. When 85% seats, my lord, the fee is to be fixed by the fee committee, my lord, it factors already that the 15% quota is for the NRI, which cannot be increased. Now, my lord, in this, my lord, your lordship may kindly see, after this order, which, my lord, has been passed in Ruchin Bharat, where, my lord, can do 2 more pages, my lord, nothing.
Yes.
Just permit me, my lord, because this impression must go, my lord.
Yes.
15% of the NRI quota is fixed. Your lordship is absolutely right. It's only bona fide candidate who must get that into admission. But, my lord, that para 131 of TMFI, which was being shown, my lord, if your lordship will just see that, in this very judgment, my lord, which is there, at page 13 of the paper book, my lord, if your lordship will just give me 2 minutes, I'll not take your lordship much time, my lord. 131 of TMFI, my lord, where your lordship said how much seats can be taken away from the private, because the governments can't open colleges, my lord, it can only be opened by now the private enterprise, my lord, where the regulatory mechanism must be in place. Your lordship said 131 in TMFI said that if you have to frame a fee structure for 85% of the students at a subsidized rate, you have to keep something a source of revenue for 15%, which must be NRI, which is para 131 at page 13, my lord, which is lordship's constitution bench judgment. In accordance therewith, my lord, your lordships had decided, kindly come to, my lord, after your lordships were given the impression it was only a temporary order, kindly come to page 17 of this compilation, which is an order passed subsequently in the case of Yenepoya University. 17, page 17, my lord, just have a look at this. Page 17. My lord, the central government, DGHS, the NMC, everybody was heard for this category because, my lord, for the subsidized fee of 85% meritorious candidate, this criteria, my lord, is approved by your lordship for the times to come and adopted by the central government and all states. Kindly see page 17, Yenepoya, where, my lord, at the last line, my lord, last para at page 17, it is submitted by Gaurav Sharma. Direction contained in Ruchin Bharat, which, my lord, is in the expanded criteria in civil appeal number are followed.
We've seen that.
My lord, or followed.
We've seen that. Yes, Mr. Bhandari. Now we can't hear it.
Lord, may I just make one submission? Lord, may I just...
Lord, 1 minute. The extended criteria is applicable in all central government institutions, in all other states. That is the recording of the...
Yes, Mr.
Can I just make one submission for your lordship's powers?
Yes, Mr. Patwalia.
My lord, even assuming that your lordships are not interfering in the judgment, I have an alternate submission to make, my lords. When this corrigendum comes on 20th of August, my lords, of the state of Punjab, my lord, we burn our bridges. We are those who have withdrawn our application from all the states, from all the categories. and we applied in pursuance to this notification. Now today the effect is, my lords, I have chartered territories which are unknown to me. Today, my lord, if I am not protected, as far as these petitioners will go, my lord, they are all out. They will lose 1 year. And my lord, on the contrary, Lord, we will lose 1 year from. Lord, I will lose 1 year on the basis of a promise. I will lose 1 year on the basis of a promise meted out to me by the state of Punjab.
We got your point, Mr. Patwal. Mr. Bhandari.
Prospectus was first published on 9/8/2024.
Yeah.
With the restricted definition of NRI that you have to be a child of an NRI and not with this broader definition.
Yes.
Everybody was told that you have to apply physical with a physical form by 19/8/2024, which was the last date.
Yes.
And the prospectus after clause 17 clearly says that once you've chosen which category you are in, you have to live with that category. You
Where is that
can't
said?
later change that category.
Where is that said?
Yes. Now, Milods, that is in the prospectus at clause 14, because Milods, the paper book that my lords have is the state of Punjab paper book, which I don't have, which says clause 14 just above clause 17.
Just give us 1 second. We'll find it.
Yes, which page in the... But because my lords are looking at the state of Punjab SLP, which I don't have. Clause 14. In my page, it's 74, but that won't be the right page number. Sadan, if you can.
I'm just we've got clause 17. Where is it?
Above clause 17, there is clause 14. 2 pages up must be.
We'll find it. Don't worry.
Very well. I'm so sorry.
On this page 6, internal page 6 of 14 of that document.
Internal page 6. Internal
fees for admission to government private medical dental colleges under NRI quota. That's clause.
No, it's clause 14, which says fill category successfully in the online admission application form. Category once claimed will not be changed in any case after submitting the form.
1 second.
14 has 3 parts. You are referring to fee, Mr. Bhandari? Fee.
Because I'm in item 322, which is 874.
You've got the. You are reading a note?
No, I'm reading clause 14, Milods, of the prospectus.
That's fee, no? Fee.
Yes.
Clause 14 is fee.
No, Milods, that's not.
How can that be?
It is fee. What? My lords, let me just see my paper book 322.
No. We'll see one paper book. Okay, they're not going to run between paper books. Now tell us, 14 is A, B, C, D, E. Fee for admission to government private medical dental institute.
I'm looking at the prospectus. Is prospectus written on the right hand top corner? Prospectus, and then it says.
We have got the notification of 9th of August 2024.
I'm looking at the prospectus which was sent to all the students who had to apply on the basis of the prospectus.
All right, we've got the prospectus of 9th of August. That is Annexure P2. All right, yes.
Mr. Farasar,
yes,
in your paper book, you have said true copy of the prospectus and notification dated 9th August 2024. So we should read this notification as prospectus, which is PDF 74, internal page 58.
Just and just assist us on this. What is he reading actually, yes, Mr. Bhandari? Just give us the page. That way we don't have to run between briefs.
Yes, but that is only the notification was to argue.
So that's prospectus. Because you have said prospectus and notification.
Where is the prospectus? Give us the prospectus. If you have a hard copy, give us a copy.
There in the second SLP, the prospectus is not there in this state.
What does the prospectus say?
Page number of
Milods, if I can read, I want
yes.
to. Milods, just one sentence I want to read. Prospectus clearly says, fill category carefully in the online admission application form, full stop. Category once claimed will not be changed in any case after submitting the form. So the point I'm making is that the prospectus clearly told the worldwide, all the students, that once you apply and you choose a category, whether you choose the NRI category or the general category, you live with that category. You cannot subsequently change that category.
Right.
Now, all students in Punjab applied as per this prospectus because everybody had to apply as per this prospectus.
The last stop date was 19/8/2024.
That you told us.
When people applied. It is only subsequent to that that 2 notifications came amending this prospectus. So, regardless of whether the wider definition should apply or the restricted definition should apply, my first ground is that the High Court has frowned upon the process that they used. First, they came up with the restricted meaning of NRI students. People decided what position they would take in view of that NRI.
20th, they issue this new process.
And then they come up with this. They come up with 2 notifications. One, they amend the prospectus to say that, sorry, now we will apply the larger and the broader definition of NRI. And second notification, they come in where they give more 15 seats to NRI quota from one particular college, which they had not given. So students also have a legitimate right to say that once we have applied as per this prospectus, now please follow this prospectus to the T and tell us whether we make it or not. That's point number 1. Point number 2, my lords, what has been shown to you is an interim order, which everybody seems to be following. But no one is bothering to read what the interim order says. It says that this interim order will only apply to deemed university and shall only apply this year. So that interim order is not a blanket John Doe order that everyone will apply forever while the matter.
Which the division bench of the High Court has noticed. Actually.
The High Court has noticed and dealt with it. So, my lords, there is no interim order which is binding on the High Court to decide this issue. Point 2. Point number 3, my lords, please see the disparity in the marks. Today, my lords, the lead petitioner has 202 out of 720 marks. I, who have won before the High Court, have 636 out of 720 marks. So, my lords, there is a huge amount of disparity.
You are the GC category,
general category.
You will otherwise get these seats.
I will otherwise get these seats. So, my lords, there is a huge disparity. Now, my lords, court has really, in PA Inamdar, the court really frowned upon the fact that this is nothing but a way to use money power for people to get in. My lords, on a lighter vein, my lords, please, I will struggle to find someone in Punjab who will not fall within this NRI definition. Everyone would have a relative. If you say first degree, paternal, maternal, uncle, my lords, there is no end to this. Therefore, it is high time. It is high time, my lords, that courts come down heavily on.
I think Brother Mushra will dismiss this, I think. This is, I think, let us put a lid on this. This fraud must come to an end.
Page 23, my lord, your lordship's order.
All the 3 petitions dismissed, yes.
Page 23 is your lordship's order, my lord, making it applicable to everybody on which...
They're all interim orders.
No, my lord.
High Court is absolutely right. We have to put an end to this fraud. This NRI business is nothing but a fraud. And look at the way the state of Punjab did this after the notification of 9th of August and the last date, which was 19th of August. 20th, you issue a fresh notification expanding the category. Ward, first degree relations. I mean, you just have to say that I'm looking after this. And look at the deleterious consequences. Candidates who have 3 times higher marks, 600 as opposed to 200, are going to lose admission. And all these people will come in the back door.
That in the given fact, each of them will get. These will get accommodated. That will also get accommodated.
We should not lend our authority to something which is a patent fraudulent category.
The central government, all states having this criteria.
The central government must now fall in line. They have followed our interim orders. These interim orders do not bind us. There is now final judgment of the Constitutional Bench in PA Nandar. We are governed by that. All interim orders say for this year, in the peculiar facts. I think now peculiar facts must give way to a principle of law, and we lay down the principle.
The subsequent order is not on peculiar facts, whereby your lordship called upon the central government to follow the law.
294. Thank you. Thank you. We have heard everybody.
Item 321, my lord. So far,
Adriji, we have heard everybody. Thank you.
No, my lord, this is different case, man. Item 321 is PG course. I am a doctor. I am a doctor, my lord. This is the MBBS course.
We'll list this on Friday. We'll look at your matter on Friday.
Kindly see.
We'll list it on Friday.
Then by that time, it will the counselling will be over.
What is the order? What is the order in your case by the High Court? Let us see. All right, 1 second. Let us see the order by the High Court.
It is a writ petition, my lord.
You have come here in a writ petition?
Yes, my lord.
Move the High Court.
We
see no reason to entertain a petition under Article 32 of the Constitution. So the petitioner would be at liberty to pursue the remedy under Article 226.
I'll take only 1 minute, lord.
Go to the High Court. Why have you come here, Kadri, and to the Supreme Court directly?
Because the writ petition is pending here.
Go there. Yes.
Then virtually there is a denial of my right. Can you see?
Nothing doing. These are all backdoor entries. These are all subterfuges to gain admission.
1 second, my lord. University has already issued notification.
That's all right. Go to the High Court, sir.
That
Thank you.
Last date, my lord, I have
Adri,
go to.
so long as you understand what we have said, we are not paid to persuade you. We are paid to hear you fairly and make you understand what we have decided. We can't persuade you to our point of view.
Lordship are impressed by their argument, other side argument. My case is I am a real brother.
Mr. Kadri, why have you not gone to the High Court under Article 226? These are robust courts set up to hear these individual grievances.
In that case, kindly give liberty.
That's exactly what I said. And you go to the High Court.
High Court may be requested to expedite because 30th is the last date, my lord. Today, this is 24th.
We have all been judges of the High Court. We know what the burden on the High Court is. They say this man has not filed a petition, or the Supreme Court is expediting a petition which has not even been filed. Go to the High Court. The High Court will deal with it. Yes.
Item 294.
Made, Mr. Lordship.
Yes, Mr. Vendugal.
My lord, sir, the last question which your lordship asked me.
Yes.
Was that section 31 which provides for an appeal based on my lord's section 100 of the Civil Procedure Code.
Yes, Mr. Vendugal.
May Lordship. Now, the question which your lordship had put to me was section 31, which provides for an appeal based on 100 of the Civil Procedure Code. It does not limit it to any person. Therefore, why should not the error be one among the persons who is entitled to take advantage of section 31?
Yes.
And my answer to that would be a series of judgments which we have cited before your lordships, including, Lord, a constitution bench. Your lordship may remember Raghunath Reddy's case, has specifically held that a quasi-judicial authority is not entitled to be heard at all unless some allegations are made against a quasi-judicial authority. Therefore, that by itself is the exclusionary basis for the error not being entitled to prefer the appeal.
Yes.
Secondly, section 18, subsection 2 sets out who are the persons who are aggrieved. Central government, state government, local authority, or any other person aggrieved. the quasi-judicial authority cannot defend its own order and cannot be a person aggrieved, so far as the appeal is concerned. Equally, my lords, even if modified by the appellate authority,
yes,
he can have no more any locus to defend his own order by going up in appeal. Thirdly, my lords,
the ERA may not have any locus to challenge its own order in appeal. No difficulty about that.
yes,
But if the order of ERA is modified by the TDSAT,
yes,
can ERA not then challenge the modified order before the Supreme Court?
my lord, for the reason that if your lordship should kindly
Original
see, my
order
lords,
passed by ERA, if
yes,
it's substantially modified by TDSAT, resulting in, say, an additional burden or something which really will dislocate the efficient functioning of the airport mechanism.
I follow.
ERA then not come to us and say that,
follow.
look, my order was a correct order. They are not strictly speaking defending their own order.
Yes.
What they're doing is they are pointing out flaws in the TDSAT order before the Supreme Court.
Yes.
Is that hard, ex facie?
I could well understand if, my lord, there are no competing, my lord, parties, and ERA is not a party, the competing, my lord, parties, who are about 8 or 10 of these stakeholders. And I'll show your lordship the order. They're all there. And one attacks the other and says that he cannot be given what he is demanding. Now, in which event the central government is there as a parents patria, expressly given a right to who as a person aggrieved. And if it finds, my lords, that the order passed by the appellate tribunal is against public interest, it is entitled to appeal.
You know, the central government is given a power as parents patria if ERA makes a mistake. If ERA makes a mistake in the first order,
yes,
then central government can go and appeal against the order passed by ERA.
Lord, I would rather say,
Does that exclude ERA from coming to the Supreme Court against a TDSAT order? Suppose in a given case ERA were to err, then who will go? Then the central government, the state government, the local authority has been given a locus.
Lord, sir, unless your lordship,
does that preclude ERA from at all coming to a higher court and saying that, look, the regulatory interests of the sector would be deeply affected if we allow this provision in the order of the TDSAT to stand?
Lord,
That's really which we have to deal with.
perhaps, my lords, your lordship will have to rethink about central government as parents patria not having, my lord, the duty to ensure that every order passed in appeal is not contrary to public interest or the intendment of the Act.
So we got your point. Your point is that once the central government's locus has been recognized in appeal under 18,
yes,
it's sort of an umbrella jurisdiction which is given to the central government. Therefore, why should ERA file an appeal? We'll hear the other side. We'll hear the attorney on this aspect. We'll hear the attorney and Mr. Solicitor also on this aspect.
Very well. Now, your lordship should note that if your lordship looks at section 18, subsection 7, which had not been read.
18(7).
18, subsection 7. The appellate tribunal may for the purpose of examining the legality of propriety.
That's the divisional jurisdiction of TDSAT.
Yes, or correctness of any dispute or any application.
Divisional jurisdiction.
Yes, referred to as an appeal of so and so on its own motion or otherwise, call for the records relevant to disposing of such application or appeal and make such orders as it thinks fit. I do not see any reason why Lord the ERA should not participate in the appeals which are preferred against his own order and take preventive steps to ensure that whatever the appellate tribunal passes is consistent with what it believes should be the correct position as a regulatory body. Therefore, it has, if my lords, the approach is correct, the right to prevent any order being passed by the appellate authority. And therefore, my lords, if it is considered that it has an overall duty as a regulator to ensure that so far as my lords, the regulatory approach is protected, it can prevent from any order from being passed, but it can't do so. It's specifically prohibited. Only the records could be produced. And therefore, if it can't at this stage prevent an order being passed contrary to what it believes, should be...
One very important aspect, Mr. Venugopal, is if you see 42.2.
Yes.
42.2 defines the role of the central government under the ERA Act, under the Act itself.
Yes.
And it says that the central government will have the power to give directions to the authority on matters of policy.
Yes.
42.1 is in the interest of sovereignty and integrity of India, the security of the state, friendly relations, public order, decency, morality.
Yes.
42.2 says without prejudice, authority in the exercise of the powers of performance of its function will be bound by the directions on questions of policy as the central government may give to it in writing. Now that shows that the central government does not really step into the shoes of ERA. Central government has a broad policy making remit. It may lay down a policy for all airports, for the efficient operation of airports. But decisions in regard to tariff fixation for a particular airport is within the jurisdiction of ERA. The central government, therefore, when the central government is a person aggrieved under section 18, that is in the context of 42. It has a broad policy making remit. But ERA has been given a specific responsibility in relation to tariff fixation for the airports. So they're separate. They're slightly different jurisdictions which are exercised by the
according to me, my lord,
and ERA on the other.
There are two provisions in the statute relating to the functions of the central government. One is 42.
Yes.
And the other, my lord, is section 18.2. And 18.2, my lord, your lordships have seen, says the central government or a state government or a local authority or any person aggrieved by any direction, decision or order made by the authority may prefer an appeal to the appellate tribunal. Therefore, this function is specific, my lords, to a particular airport or the class of airports and a decision of the ERA. And therefore, this is a totally independent function, and that is a function of laying down policy in advance of the ERA taking a decision on any issue which comes before it, regulatory issue or otherwise. And therefore, my submission is the 18.2 is otious.
Yes, Mr. Venugopal. So we
And
got
therefore, my lord, so far as
the central government has an appellate power under 18(2).
Yes.
So in 31, it's really the central government which can file an appeal and not ERA. We got your point. We'll hear Mr. Venkatraman on the other side after arguments are
Yes.
over.
Therefore, my lord, so far as this is concerned, my submission to your lordship is, my lord, first of all, take a broad look. Does the fact that an authority is a regulatory authority with clear-cut functions, which may be administrative functions, as against, my lord's quasi-judicial functions, if, my lord, the quasi-judicial functions are put into a compartment, does it change the nature of the fact that the judgments are held that a quasi-judicial authority cannot be heard? Was there an attempt by this Act to not compartmentalize its quasi-judicial powers from the executive powers?
Actually, there are two competing arguments. We have to decide which is the correct one.
Yes.
One is that Section 18 provides who can file an appeal against an order by ERA. 31 is silent who can challenge an order passed by TDSAT in appeal. One interpretation which you are suggesting, which is that anybody who can file an appeal under Section 18(2) should be the persons who are entitled to file an appeal under 31 and no other person. Because ERA is essentially a quasi-judicial body and it cannot challenge, it cannot step into the fray. That's your interpretation. The second competing interpretation is 31 is advisedly silent on who can file an appeal and therefore don't restrict 31 to only the parties under 18(2).
Very well, my lords.
These are the two competing considerations. You are supporting the first on the ground that ERA is a tariff fixation is a quasi-judicial power, and the quasi-judicial authority has should not really jump into the fray and start challenging orders passed either by it or by the first appellate authority. We'll reflect on
my approach was a broader approach, my lords. My approach is take a quasi-judicial authority under a regulatory regime. If, my lord, an effort has been made by Parliament to compartmentalize the quasi-judicial powers and, my lord, particularly say these are the objective criteria on the basis of which you will fix tariff or fees, and then say you will put your proposal in the public domain. You will invite objections. You will then hear them orally, because we find, my lord, from the proceedings that oral hearings are also given and submissions are made in their presence, and then an order is passed. Then this is not a statute by which you are compartmentalizing, my lords, the quasi-judicial powers. And what is more, the appeal has to be preferred, my lord, by invoking Section 100 of the Civil Procedure Code. Section 100, my lord, is purely, my lord, quasi-judicial. It deals, my lord, with judicial powers. Therefore, the administrative orders, my lords, passed by the ERA can nowhere come under Section 31, because there can be no the Section 100, my lord, being attracted by, my lords, a administrative order. Therefore, my lord, my respectful submission is the Act was specifically designed to separate, my lord, the quasi-judicial powers and provide that only the quasi-judicial orders would go up, my lords, in appeal to the Supreme Court. And if your lordship would enlarge it, then your lordship shall have to say administrative orders also will go up to the Supreme Court under Section 100, which is not possible. Therefore, there are more than one indication as to why.
All right. Thank you, Mr. Venugopal. Anything else? We'll hear Dr. Sangeet.
Then secondly, my lords, they have relied upon the OMDA and the state support agreement. This is wrong, I told you. They are all prior to the act being passed. Those are executive contracts not entered into. But Parliament takes over subsequently. And a law is passed. Omda Millards have nothing much to do with the issue.
All right. Yes, Mr.
Then please, Millards, take the volume relating to page 517.
This is volume 2.
It is volume 2
Civil appeal.
of Civil Appeal 8217 of 2023. And please take page 499. It says 499. The following stakeholders commented on the authority's consultation paper in the matter of tariff determination for Delhi International Airport Limited. And your Lordship finds Airport Council International, Air India, Airline Operators Committee, Air Passengers Association, Association of Private Airport Operators, SOCHAM, Blue Dart, Confederation of Indian Industry, Delhi International Airport Limited, Federation of Indian Airlines, Federation of Indian Chambers of Commerce, then the International Airport Association, and any number of them. And then at Millard's page 517, your Lordship shall find the argument of the Federation of Indian Airlines at para 3.29. The last sentence of that is sixth line. The argument is that Dial's approach, that is the airport operator, approach of hybrid till deserves to be discarded. Therefore, there is a competition among them, and the Airlines Association, Federation of Indian Airlines, says that so far as the airport operator is concerned, its argument has to be discarded. Therefore, all these parties are there before the Appellate Authority, and they argue against each other as to what the particular private interest of each one of the associations would and therefore, my lords, my respectful submission is the judgment, my lord, cited by Mr. Venkatraman, namely, my lords, the Competition Act specifically has a provision by which the Quasi-judicial authority under 53T was permitted to file an appeal. Why was not that here? And if not, the intention was for the provision, if they wanted, they had to file an appeal. And my final argument is that judgment itself has a paragraph which expressly says that the right of appeal should be expressly provided for and not by intention. And what my lords is putting to me is that can we not cull out the intention from this? Perhaps your lordship is having in mind the two other regulatory bodies, SEBI and TRAI, and that will depend upon the statute, just like the Competition Act. And therefore, my lord, this can't be a blanket list. That's my suggestion.
Thank you, Mr. Venugopal. Dr. Singhvi, you want to add something? Dr. Singhvi, yes. Mr. Datar, who would like to go first?
Yes, now, let's, your lordship has heard detailed arguments, so I'll make them in point form. I've made two notes. One note is a rejoinder note, which I'll hand over now. There is an original note earlier, which one or two portions the lordship may see, including quotations from the Jindal judgment of Karnataka. And then I want to give a chart of other acts as a comparative. These three things I want to do. Whereas my first respectful submission is that your lordship will look at these issues in a very important backdrop. And that jurisprudential backdrop is much more important than the nitty-gritty of what we are arguing. And that is this, brothers. There is not an iota of doubt that this authority adjudicates tariff. Heavily contested, counsel appear, all kinds of arguments are made and it comes to. Means the larger approach of the court in holding one adjudicator to be a litigator will have far-reaching repercussions across the country. Just keep that as a backdrop. I'll give a lordship the other statutes. Your lordships have not intended in this country for adjudicators to be active litigators. And this judgment of your lordships, obviously lordship doesn't write a judgment only for this case, your lordship writes it for the law as such, will have repercussions. So there must be a very, very serious look at the contention of the other side at this point. Now, having said that at the outset, please turn to my rejoinder note. Give it. It's very pointed and won't save a lordship's time. Give it to the others also. Now, in this note, I've tried to deal seriatim. The first is, your lordship may ignore the left side because broadly the arguments are given there. We can always look at it whenever your lordship wants to, but it will save time. My first submission on this right side of the chart is, that 18.7, which my lord has seen many times, has not only legality or propriety, but has examining the legality or propriety, and also says call the relevant records, and also says on its own motion. These are quoted in my first box, variously. So 4 elements. I've not been able to highlight all correctly. On its own motion, examine, legality or propriety, and direction, decision or order. This is completely inconsistent with the legislative intent to allow errat to be an appellant, direct appellant in the Supreme Court. It cannot be, that your lordship has this kind of suo motu power and yet is an active litigant, because the active litigant is then fully entitled to file an appeal itself. The appellate tribunal need not have these powers. That's point number 1. In cellular operators, your lordship said this. TDSAT itself is an expert body and its jurisdiction is wide, having regard to subsection 7. Its jurisdiction extends to examining the legality, propriety or correctness of a direction or order or decision of the authority in terms of subsection 2 of 14, as also the dispute made in an application. So, this is rendering, reading down to vanishing point, or otherwise, making superfluous 18.7 is the first point. The second aspect.
When you say that TDSAT can itself call for the records, examine the record and pass such appropriate orders.
If there is an active litigant, which is errat or error, I'm sorry, not error, then that is not necessary. They will decide when to file an appeal.
Who is the active litigant?
Error. And otherwise, the two active, that's coming down later. Otherwise, they provide you enough locus to an active service provider and an active service recipient. They don't shut out anybody. We have done enough cases, all of us here, before even the tribunals under this jurisdiction. There are any number of times when a passenger association comes. Any number of times, mostly it is FIA. I believe FIA is today also. Today also. Federation of Indian Airlines. There is no dearth of competitors or litigants. My lord has been given an impression by the learned law officer that if I am not there, who will protect? It is supposed to be adversarial which will protect. Your lordship's intent is where there is adversarial intent, then you will protect. I don't accept the fact that the tribunal can have adversarial intent.
That the service provider
and service recipient.
Right. The service provider has a particular perspective. The service provider usually
like me.
Right. You are the person.
So it has one perspective, no doubt about it.
Right.
It has one perspective.
The service recipient would be, say, the passenger association.
Airlines.
The airlines, because they are receiving the service which is provided by the airport. So these are again sectoral interests. Within the sector, there are interests. Can that be equated with the interests which ERA espouses? ERA espouses a much broader interest which covers this and more.
Kindly see. ERA is not intended to be a public interest litigant. Give me a minute. I understand what
regulator.
He is not a regulator actually. The word regulator has been used again. He is not a regulator. He is a determiner.
Not regulator, it's a tariff determiner.
He is a determiner. Regulation is that's important. That's an important. That word is being used. It creates a penumbra of meaning. He is not a regulator because a regulator has those macro perspectives. Maybe, I'm not conceding, in a particular regulator's case, it can have a public interest perspective. This man is a determiner / adjudicator of tariff. That's it. He doesn't. He cannot lay down any policy for the sector. Today, Malus, suppose a non-tariff issue comes before him, where there is some other policy, he cannot decide. He cannot. He should not. No provision. Your Lordship is actually, Malus, subtly being asked to expand contrary to the statutory intent. And therefore, Malus, my point, it comes back to this point. Malus, it is the adversarial intent in individual cases which is to be adjudicated. My Lord says it is sectoral. It is intended to be sectoral, but the intent will cover all sectors. There is a cargo association also, Malus. There is an airline association also. There is a passenger association also. There is a flyers association, Malus. No interest is left out unless the law officer wants to suggest, my learned friend, that the interest left out is a macro PIL kind of interest. That this whole statute doesn't suggest anywhere. Nowhere. So that is a very important perspective your Lordship will keep in mind. Now let us kindly come to my second box at page 2. My Lord has got my, that is on the left side is serial number 2. It is very clear.
This one.
Move to the second point, I want to emphasize at the cost of repetition, Balaz. No interest which your Lordship is being given an impression of is left unattended.
That point to Mr. Venugopal.
Because, Balaz, it is an impression being given.
No. That ultimately, argument was that, look, all stakeholders are before.
And Balaz, ultimately, every interest is covered. There will always be an interest which will be sectoral. Interest can't be macro. And there is no sectoral interest which is intended to be excluded. In this connection, as I leave this point, we'll just see the preamble also.
The second point you are saying is that they determined aeronautical tariff.
Yes. Now, just before that, 1 second before that, just turn to the preamble of the Act, just for 5 seconds. Can you take the Act, the preamble? This authority is made for a very specific purpose, which makes it clear it is not in that sense, whether somehow the word regulatory has come, that will not be dispositive of your Lordship's interpretation.
To regulate tariff and other charges in aeronautical service.
So, tariff doesn't mean only tariff in that sense. Any service, the cost of that, the price of that. The whole purpose is this, and the SOR which preceded say the same.
So, what is your submission, Dr. Singh?
Therefore, it is a adjudicator for tariffs. It is not a macro regulator. It is not a policy maker. It is not a public interest litigant with a statutory entrustment of responsibility to be a public interest litigant. That's the point I'm making. And in tariff determination, there is no segment affected in a particular case which he cannot decide. Well, let's take a case. I'll give a graphic example. Take a case where a person with no tariff issue or no cost or price issue comes to the regulator and comes to this authority and says, please decide my grievance. Suppose there is no cost or tariff issue. Take it the reverse way. My humble and respectful submission is that the authority can't touch it. I don't know whether he may come saying, okay, this airport requires extra land on the side. It's too congested. This airport is delaying flights because the timings are bad. They're all airport issues. It will have to go to the government. It will have to go to MOCA. It will have to go to AI. It can't go to the regulator.
Now the second point.
Now the second point. This para 2.
We've seen that.
Now let's just see. The word tariff I have emphasized from the word also preamble. Now come to the third page. In the matter of determination of aeronautical traffic, these are the control periods. Each title is like that. Each order is like that. In the this is important. 3.
This second point you've got.
Yeah, now 3 is important because this is how the consultation work. In the consultation process, after the paper is issued,
Dr. Singh, that consultative exercise is done.
Well, which stakeholder is left out? I'm asking myself. Kindly appreciate this. No stakeholder is left out. Then, forget the fourth one. Come to fifth. It is tried to mention that while determining the aeronautical, it should be tariff. Word is missing. In the entire scheme of airline cost structure, this lordship should know impression is given. It is only maximum 10 to 12%. It suggests as if the whole thing, and we've given the breakup of some other subheadings. 4, page 4. It's an adjudicator, cannot be a litigator. My larger point. Now, much is made of a completely inconsequential provision. He has to be given a copy. On the contrary, that provision makes it clear that you are not a party. Well, your lordship says that for compliance, for implementation. Well, everybody who is entitled, it's a statutory authority after all. An order is passed. It should know about it. Tomorrow it has to act in spirit of it. So everybody who gets a copy on a procedural basis becomes a party, entitled to file appeals. Well, this will have very far-reaching consequences. This argument cannot arise because several statutes have this procedural provision. The real test is it an aggrieved person? Aggrieved, your lordship understand what's an aggrieved person. It is a person who's affected by passengers.
We've got the point now.
Just a few minutes.
I think we've heard you on.
Well, lordship gave me 20 minutes. I will not even take 10 minutes.
You want to wrap up by lunch, huh? Everybody will. We have to give about.
No, well before lunch. Well, I will do it 5-10 minutes more. 10 minutes more. Then, now next comes the form.
No, we have to wrap up the entire case by lunch because we want to start something to after. Yes.
The form, is the next point. I'm asking myself, how does the form take the story further? Either way,
Yes.
Does the form indicate anything? These are searching for straws in the wind. The form is neither here nor there. Now, there is a very important, I think a useful chart has been made here.
Yes.
You see this chart. It is not required to be read, but I must emphasize a few lines. Your first is your Lordship's Act here in this case.
31.
Now, just glance at a few things. Just see the contrast with 261. My Lord has handled enough income tax cases here and there to know it's a direct, clear locus given. And your Lordship does not interpret appeals by interpretation or inference. Appeals are specific, substantive, statutory rights given. Now come to the third one. Now this is utter confusion with great respect, leading to your Lordship competition appeal cases. 53T. And I would add, the other 53 also, which is or the commission is mentioned in the statute. I'm sorry, this is very important. My Lord has got the second line.
Yes.
Or the commission.
We saw that.
How do you cite CCI and Steel Authority of India?
And then you have said that, well,
now,
the CGST,
customs now. Your Lordship will give intent and meaning and furtherance to the statutory intent. Your Lordship will not take it casually that everything is the same, which is what the other side's argument is.
Right.
Then let's take as diverse. Look at the diversity I've given. GST. Electricity Act. Your Lordship handle these cases every day. The repercussions will be far. Of course, leave aside telecom regulatory. Come to Petroleum Board, item 10. Petroleum Board, item 10. Your Lordship will start, Petroleum Board decides all these hydrocarbon matters, will start coming in appeals. It's a complete adjudicator, Pension regulatory fund, your lordship will have appeals from them. A judgment of your lordships must sync with the overall statutory scheme of the country. There are 10 statutes here. And my learned friend's argument I submit, in fact, indirectly invites your lordships to drive a coach and four through these. One more thing and I'm done. Just take a compilation email to your lordships, only the headings, the case law. Index is very useful, I don't want to read it. Just take that compilation. Have you given it, please? Just give it. Just the heading, only the index. I'm not going to read a single case. First is your lordship is not dealing with tabula rasa. Your lordship has got nature of quasi-judicial. Now, is it anybody's case? Yes, I'm not reading any, but is there a denial by anybody possible that is not quasi-judicial? Answer no. If it is quasi-judicial, from Kushal Das Advani, which your lordship knows well, right up to Gulapali, I've given them all in my index. My lord has got the index. Express newspapers. Now, specifically, I've given number 4 and 5. Tariff fixation is quasi-judicial. I'm sorry,
yes, PTC and BSCS right.
Direct Supreme Court judgments. Then, these two judgments are important. That quasi-judicial should not defend its order before the High Judicial Forum. These are important judgments. One is Bombay and the other is Allahabad. Now, there is a missing judgment here. Lordship may kindly see my original note where I quoted, I had the privilege of arguing in Karnataka High Court. Jindal. Now, that Jindal is quoted in the first note given to your lordship. Lordship doesn't mind just.
What is the citation of Jindal?
Yes. 2004 SCC online Karnataka 204. The paras are 33. And if your lordship doesn't mind my first note, page 6 quotes it. I'll read it slowly to your lordship. It quotes it. In my first note, page 6. Took the view that Karnataka Electricity Regulatory Commission acts quasi-judicially in passing an order and quote, if ultimately this court decides to remand the proceedings to the commission for fresh consideration in exercise of its appellate jurisdiction, the commission having contested the matter before this court with abnormal interest and the psyche of a private contesting litigant cannot be fair enough to decide the issue with impartiality and discipline. But this is far larger issue of the very structure of this country. You don't, nobody's talking of bias.
How will they apply their mind?
Institutional bias, we all understand. We cannot, even if we try, we cannot transcend it. We can all give large words, but the practice of it, your lordship knows, is very difficult to transcend or overcome your institutional bias. So why should your lordship, unless my lord finds a casus omissus somewhere, some huge public interest is left out. There is no public interest left out. And there is, lawyers are out there. People argue vehemently through lawyers. A judgment is given. And then the same person starts filing an appeal. Look at the consequences. And this affects 6 or 7 sectors I've given, all of them. There is another case which I'll hand over, but these are the basic submissions. Your lordship may. Gridco, is quoted in my first note. Kindly tell the court the first note. Those two are very important. Yes. Gridco and Jindal. I've quoted it. I'm very deeply obliged.
Thank you, Dr. Yes, Mr. Gata.
Just about 5-7 minutes. I may not know. I've given it once.
I'll take your lordship leave.
Yes, sir.
Well, I'm confining myself to the scope of section 31 and also, my lord, the function of error. Just 2 points. Lordship will see my note, my lord. First point, they've been made already. When Parliament, Lordship has got my note, my lord. It's on the screen.
Oh, it's on the screen. Yes.
So the first point is, my short submission is, if Parliament has given powers to SAT and CCI and not given it to ERA, it must be presumed to be deliberate. Now, ERA is working for the last 14 years.
Right of appeal to SAT or to SEBI, you mean?
No, right of appeal of SEBI to SAT, correct. My apology.
Given right of appeal to SEBI
to SAT and CCI to NCLAT. So it has to be a parliamentary function. If Parliament feels after 14 years of functioning of ERA, this body needs to have a right of appeal, it can do so. This can't be done through a judicial order without meaning any disrespect. Number 2. Now, my lord, I studied appeal provisions. They are broadly in 3 categories. In the first category, the appeal provision does not mention who can file an appeal. I was surprised, my lord, when your lordship mentioned neither section 96, first appeal, nor section 100 says person aggrieved.
Person aggrieved.
It just says appeal can be filed.
In fact, from Dr. Singhvi's chart, I was just noticing some statutes say any party.
I'm coming to that. I made a chart of
Some statutes say any person aggrieved.
Yes, yes.
Some statutes are silent.
Yes. So first category, nobody is mentioned.
No mention.
The second category is the most common, any person aggrieved. The third category is the rarest, which
Any
is
party.
any party. And I've given annexure 1. Lordship will just come to annexure 1.
In fact, person aggrieved, the words are used in the Electricity Act, in the Major Port Trust Act, then 15Z of the SEBI Act.
Yes, yes. No, Lordship will see.
And finally in the Pension Fund Regulatory and Development Act.
No, actually, any person aggrieved like a default. Advocates Act, section 37 and 38. And I realized, Dabholkar, when in Sirvai they said Advocate General has no right of appeal. So they amended the act. And then that came before Dabholkar. So just you see the annexure, Court Master, take it up. Take it up. Annexure 1. Yes. Now, Lordship will see the act. Companies Act, any party to the proceeding. Lordship has got that. Then I've also taken state legislatures. Take Bihar Private School Fees Regulation. Any party may prefer appeal. Guwahati Municipal Corporation, any party to the appeal. Delhi. So I'm submitting that where the legislature wants to give a right to one of the litigants, any party, it says a party can file an appeal.
But what happens in a case like 31 where no party is mentioned?
So that's my second submission for Lordship's kind consideration. Relying on Dabholkar's observation, Lordship will just come to the next annexure, which is the case law. My submission is if the section is silent as to who can file an appeal, by default, only a person aggrieved can prefer an appeal. It can't be that because the section is silent, any party to the appeal can file an appeal. Otherwise, there was no need for having express statutes covering that. And why do I say so, Malot? Please come to the next quote. Take it up. Annexure 2. Please see Malot Dabholkar. And Lord, I just mentioned one thing here.
And who would be the person aggrieved?
That's a zero-ice case. Person who has caused prejudice, material thing adverse to him, and so on. I'm coming to that. And Lord, I've started using the ESCR. I'll sit with your people, but the search engine has to be slightly tweaked. And some features have to be added. If your Lordship permits me, I can talk to them because I've been using it now.
Yeah, why don't you just send me a little email or a
yes. For example, my Lord, the search engine has to be tweaked. And secondly, my Lord, that followed reference is not there. Suppose you got, say, for example, Chiranjit Lal Chaudhary in 51 Supreme Court. If you go to SCC online, it tells you it's been followed in 137 cases.
We'll immediately put that in.
So I can sit with them and because we are using.
I'll ask him to meet you, right?
Yes.
Thank you.
Now, my Lord, please come to Annexure 2. I have now taken the SCR citation and I have put the placetum because there are no paragraph numbers. Please see first sentence in the judgment of 7 judges of Justice Ray. When a right of appeal against an administrative or judicial decision is created by statute, the right is invariably confined. Please see the words. Though it's not a statute, the right is invariably confined to a person aggrieved or a person who claims to be aggrieved. The meaning of the word person aggrieved. Yes. And then, Lord, since we have to finish the wrap up by lunch, Lordship will just see further it means the person aggrieved, where like human rights is involved, they're given a liberal interpretation, where it's contractual, they're given a narrow interpretation. But I'm submitting that the person has to demonstrate what injury is caused to him. And now please come to Adi Firozshah Gandhi, which is by 5 judges. Please come to the next page. But in fact, Krishna calls in one judgment, person agrees as a hackneyed phrase.
Says?
Yes. May I read it? I thought the Lordship was in.
Of Dabholkar?
Yes. It's para 29 of Dabholkar in the SCC online.
Right.
But I've extracted it from SCR, Lord.
Yes.
Can I read? The meaning of the word a person aggrieved may vary according to the content. Sorry. The 7th judge. Yes. Well, that's very interesting. What they say is the Bar Council, keeping in mind the role of lawyers, is a party to the list. So it may be between disciplinary proceeding and the individual advocate. So they discuss the whole thing. This should not apply to an economic regulator like ERA.
Yes.
Now please come to the Adi Firozshah Gandhi case. And if your lordship comes to the next page. Yes. Now just see on top. Yes. Lordship will kindly see the next page. Please come up. Yes. Yet these definitions. No, next page. Come on. No, sorry. Lord, it sees the word. Yes. Lordship has got the word, yet these definitions.
Yes.
Yet these definitions. Because he says it's been used number of times. Krishna in his own ways, my Lord, says it's a hackneyed phrase. But here, my Lord, what Justice Hidayatullah says is, yet these definitions are not entirely without value, for they disclose certain unanimity, Lordship will note, certain unanimity on the essential features of this phrase, even in the diversity of the context. The font and origo, which means source and origin, of the discussion is the well-known definition in so-and-so. It was observed that a person aggrieved in section 71 of the Bankruptcy Act meant not really a person who is disappointed of a benefit or he might have received if some order has been made. A person aggrieved must be a man who has suffered a legal grievance, a man against whom a decision has been pronounced which had wrongfully deprived him of something or wrongfully refused him something which is wrongfully aggrieved. Now please come back to my note. My humble submission is, if your lordship is pleased to lay down the law, that if a section is silent, then following Dabolkar and Sirwai, it must be a person aggrieved unless legislature says any party can file an appeal. Now, second submission is, every proper or necessary party is not necessarily a person aggrieved. Every proper or necessary party is not a person aggrieved. That's why the legislature says any party to the appeal may file. And lordship has sat on the first appeal bench, second appeal bench. Only the person aggrieved comes to the first appeal or to the second appeal. Now kindly come to 2.6. 2.5 I am saying, it is no concern to ERA. I'll come demonstrate this later. If there is modification or variation out of fixing tariff. Now please see the appeals. In the present batch, 6 out of 10 appeals are by ERA. In civil appeal 3098, the grounds are from A to FFF. And civil appeal 827, it is from A to ZZ. So if your lordship sees it's a travesty of justice, non-application of mine, all these phrases are used. Virtually, ERA wants to restore its own order. Every single point where there's a variation, he says the tribunal is wrong. This is not the way my lord or adjudicator should do. Now, so the first submission is 31 must be interpreted and restricted to a person aggrieved. Now we have to decide whether ERA can be aggrieved at all. That takes us to section 13. Now, my lord, we have done this first matter before the Supreme Court. What is the role of ERA, my lord? We have been talking so much about ERA, regulation, public interest. Please come to the last page, the formula, the annexure 3. Just come to annexure 3. All that ERA has to apply is to apply a formula with 6 variables, nothing more, nothing less. Please come to annexure 3. Now, kindly read the first line. Lord,
this is schedule 1 of the state support agreement.
Yes. In undertaking its role, ERA will, subject to applicable laws, observe the following principles, and lordship will note 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And lordship will kindly see in 10 there are subclauses. First point, lordship will note 1 to 10 do not use the word public interest at all. No reference to public interest. And Mr. Puya pointed out the objects and reasons there is no public interest. Now please come to 4, usage. Lordship has got usage just above the bold.
Yes.
Lordship has got usage.
Yes.
In general, aircraft operators, passengers, and other users should not be charged for facilities and services they do not use. So some kind of quid pro quo is involved. So in proportion to what you use, charge should be there. Now, this is the most important thing. In calculating revenue charges in the shared till inflation X price cap model, the revenue target is defined as follows. TR is target revenue. Lordship has got that.
Shiradonkar will meet you.
I can just 10 minutes more. Lunchtime, I'll speak to him.
It's okay at lunch?
Yes, yes, yes.
Tell them a bit. Tweak our ESCI. It's part of my passionate mission. So,
yes. There are some 3-4 features I wanted them to add, Milord. Milord, the revenue target is defined as follows. TRI is equal to RB into W so and so, so and so. Lordship, forget about the.
Jaggi, you also meet Mr. Datta.
Yes. But
no, I was telling my team.
Yeah, sorry. So, Milord, my humble submission is, what is the role of ERA? It has to determine the target revenue. How much should the airport get in a control period of 5 years? How does it do so? It has been laid down in a formula of 6 variables. Regulatory base. Now, please see WAC. The Lordship is doing so many tax matters. Please see WACC, which we argued. Nominal post-tax weighted average cost of capital calculated using marginal rate of corporate tax. So we have to argue what is marginal rate, what is nominal rate. So these are all questions of law will come before you. So the point I'm making is they completely apply this formula and come to a figure of 46. Now let's say, my lord, they hold the list to stakeholders. According to the airport, the TR, targeted revenue, should be, let us say, 100 rupees. According to other representation, it should not be more than 55 rupees. Typical. So you got the delta between 100 and 55. TDSAT says, no, it should be 60 rupees. Or say, let's say 70 rupees. Airlines will go and say, no, 70 is too low, it should be 100. Other person will say 70 is too low, it should be 55. TDSAT places it at, let's say, 63. It comes to your lordship. Your lordship then decides what's the actual figure. Then what happens is, by the time the matter is decided, 3-4 years may pass. Suppose your lordship varies it, it will be recovered from us in the next period or be refunded to us in the next period. So my humble submission is, once the target revenue is determined by ERA, the person aggrieved will be either the service recipient or the service provider. By definition, one must accept that there is a quasi-judicial tribunal headed by a Chief Justice or by a retired Supreme Court judge. That tribunal decides that the decision on the variables my lord, we can refer to Wednesbury that the tribunal, that the ERA did not consider relevant provisions, non-relevant provisions. Yes, you're correct. That's why the word Mr. Singhi pointed out, the tribunal decides the legality, proprietary, correctness.
All right.
Yes. So my humble submission is, that's why ERA can never be.
Anything else?
I agree. That's all my submission. Yes. And the last point is, I only want to mention that fixation of target revenue, I'm only submitting is that the whole allegation, there's no public interest in it. It's a pure matter of contract. We have been asked to bid at the airport. The government called all private parties and said, you please take over the airports. It can be a greenfield airport, it can be a brownfield airport. And we were told that if you invest money, you will get target revenue as per this formula. Now, this can't be varied on some notions of public interest and so on. In fact, the review petition filed by them against an order of the Supreme Court allowed our application. One circular had not been considered. So Supreme Court has remanded the matter to TDSAT to consider the impact of the circular in the earlier period. Now, ERA has filed a review petition saying Supreme Court non-application of mine, travesty of justice and so on. I am saying you have done your tariff, your job is over. To use a word, they are functus officio. They are functus officio. That's all. They can't prefer an appeal. That's my submission.
Hello. Just one submission, Manoj. I won't take more than 45 seconds. This is Puvaya, Manoj. Manoj, just to add to what Manoj, Mr. Datar submitted, and Manoj, Dr. Singhvi's submission, I'm only on the point of whether tariff determination can be anything other than quasi-judicial when it comes to ERA exercising power under Section 13. My respectful submission is that it is only quasi-judicial also because, kindly see for a minute, Section 44 of the Act, which specifically bars the jurisdiction of a civil court in any such determination. Which means other than that bar, the civil court would actually be determining something of this nature, two contesting parties in terms of what the tariff should be. That power, my lords, there is two sections. One is Section 44, one Section 28. 28 bars the jurisdiction of civil court vis-a-vis the appellate tribunal's activity because the appellate tribunal also adjudicates at first instance under 17(1). And Section 44 bars the jurisdiction of the civil court specifically for ERA's activities. Therefore, my lords, for ERA to turn up and today say that my activity is really not quasi-judicial, it is maybe legislative, but it may be regulatory. A third animal, my lords, regulatory, may not be correct.
Okay. Thank you, Mr. Puya. Yes, Mr. Venkataraman.
What? Milord, I believe Mr. Puvaya has been muted. Can you please be unmuted? He just has to make one submission queer judgment that has to be handed over, Milords.
Mr. Puya, something else remaining?
One
My
judgment.
lords, there's one judgment which I will just place, my lords. I just wanted to make one sentence. My lords, if the logical sequitur of the other side is correct, then under 18.7, when Appellate Tribunal sets aside an order suo moto and remits the matter for consideration, the first authority will not remit, to take it on remit, they will, my lord, challenge the supervisory order also, my lords, in appeal. That's all I have, my lords. I'm grateful.
Thank you. Yes.
Can I start after lunch? Because after lunch.
So about 15 minutes or so.
Oh, Lord, what we have done, whatever they have argued till yesterday, we have prepared written submissions.
Okay.
Just show us that. They have shot up some new 7-8 points. I will address them.
All right.
All of them can be addressed. No problem. They are starting from saying that we are not regulators. We'll have to address that. Our status is under dialogue.
Whatever they have argued today, you can update your written submissions a little later, maybe in half an hour or so.
I'll do that. Can you place the written submissions?
Yes.
Immediately. Take your patience.
Mr. Datar, our team will just sit with you about the digital SCR. Have you used the digital SCR also?
No, I've used the
Use the digital SCR also because that has a page flip option also.
Okay,
they'll sit with you.
The control room.
Check, check, check. What is check? Check. Usman?
Yes, yes. Yes. हमारा तो रेडायल में था ना मतलब।
वहाँ एक बार वेट करना, ऊपर डायल से भी टेस्टिंग करवा रहे हैं।
हाँ जी। जी रवि जी आवाज आ रही है।
Check, check. Audio check.
यस यस। हेलो।
All colors.
Check, mic check, check.
I'm sorry, I had an urgent administrative meeting which kept me back actually.
Lord, there is an item 73.1 today. Tax effect is below 5 crore. It is a public sector undertaking. It's a money deposited under the EPF slight delayed deposit. And Lord, it's a...
You're for the respondent?
I'm for the respondent.
I'll just check it up.
73.1.
Check on Monday.
Monday, let us know.
Monday, DPO.
We'll check that. 73.1.
73.1.
Yes, Mr. Venkataraman.
Yes.
Lord, what we have done, submissions made till yesterday, till the last hearing, we have mailed it, my lord, to your lordships.
Brother Mishra, sorry to keep you waiting.
No, it's all right.
Sincere apologies, brother. Yes.
But we have mailed the written submissions.
Yes.
This far argue.
Let's quickly run through them.
Yes. Your lordship will please. And then address the 5-6 questions which was raised today.
Today.
Lordship wants a hard copy, I can have. Mail it. Sir, just want to check KKV sir's office has received it. Sir, you have received your submissions.
I'm not sure, but I'll go through your submissions. You just please.
Oh, brother Mishra, they have emailed it to your secretary. So if he can just give you, then you'll be able to.
Okay. I'll just go through.
Yes. Yes. Lord, these are the questions framed, my lord. These are the issues argued by them, which to the best of my ability I have captured it. The airport operator submissions are as follows. ERA, which is a tariff fixation authority, cannot be an aggrieved party at any stage of the proceedings. When it cannot file an appeal before the TDSAT, it also cannot file an appeal before the Honorable Supreme Court. B. The definition under Section 2O of stakeholders, which includes any association of individuals, which in the opinion of the authority represents the passenger or cargo facility users. It is good enough to defend the interest of the affected parties, and therefore there is no need for ERA to be a party to the dispute before the TDSAT or prefer an appeal before the Honorable Court under Section 31. C. ERA is not a protectionist of public interest and therefore cannot maintain an appeal. D. Fixation of tariff by ERA is a quasi-judicial function and therefore appeal by ERA is not maintainable. E. Unlike Section 53T of the Competition Act 2002, which empowers the Commission to prefer appeal before the Honorable Supreme Court, no such parallel power is found or embedded in Section 31 of the Act, empowering ERA to maintain an appeal before this Honorable Court. F. When a legal consequence by way of remand is available to be directed either by the TDSAT or by this Honorable Court to ERA, in which case it needs to redetermine the tariff and therefore disentitled to maintain an appeal, or else the same would result in bias.
These are the key, even if you take into account today what is argued, this is the key really.
I thought I'd catch. We have addressed all of them, my lord. It is respectfully submitted that none of the above grounds are maintainable either on facts or in law. Section 2O defines a stakeholder as, and I'll skip the definition. The role of a stakeholder vis-a-vis the authority is referred to in Section 13(4) of the Act, and the same reads as under. The authority shall ensure transparency while exercising its powers and discharging its functions inter alia, A. by holding due consultations with all stakeholders with the airport, B. by allowing all stakeholders to make their submissions to the authority, and C. by making all decisions of the authority fully documented and explained. A stakeholder, such as a licensee of an airport, an airline operator, or a person who provides aeronautical services besides being a stakeholder, may also be an aggrieved person having the capacity to contest disputes and maintain appeals. But when it comes to any association of individuals who may represent the passenger or cargo facility users, being not direct service providers, may not really be directly aggrieved and need not necessarily take up disputes relating to passengers in appeal in every case. But I just pass here to say, we go on record to say, so far in the history of TDSAT, not a single appeal has been filed by passenger cargo. I have instructions from ERA. Not a single appeal has been filed so far. 6. It is important to submit that there is no mandate under the Act or any of the regulations permitting or obligating such type of stakeholders to vindicate the rights of passengers or matters involving public interest. There is nothing in the Act to suggest that they would effectively represent the cause of the passengers in contesting disputes or maintaining appeals. The definition under 2.0 defining stakeholders is an inclusive definition and therefore may include trade bodies or other organizations which can, in terms of section 13.4, be allowed consultations or make submissions, but there is no statutory obligation to make such stakeholders to contest disputes or maintain appeals on any aggrieved section arising out of tariff fixation or revision of tariff by appellate forums, and therefore this submission requires to be rejected. Section 13.1 and Section 13.1a provides different roles to the authority. 13.1a permits the authority to determine tariff for the aeronautical services, taking into consideration the stipulated factors in subsections 13.1b to 13.1f. Prescribes yet another set of functions which include calling for such information as may be necessary to determine the tariff under Clause A, Section 13.1e, or to perform such other functions relating to tariff as may be entrusted to it by the central government, or as the case may be, to carry out the provisions of the Act. On the other hand, 13.1a disables the authority from determining the tariff or tariff structures, etc., if the same are incorporated in the bidding document, which is the basis of the award of operatorship of that airport. However, the proviso makes it obligatory that the authority should be consulted in advance regarding the above referred subjects in section 13.1a, which are to be incorporated in the bidding document. Consequently, the role of the authority is twofold. It determines tariff under section 13.1a and is being consulted for fixing the tariff in bidding document under 13.1a. Now coming to section 17 and 18, they deal with appellate tribunal and the application of settlement of disputes and appeals to the appellate tribunal. Section 17a provides original power to the TDSAT, hereinafter referred to as tribunal, to adjudicate any disputes. And section 17b provides for appellate powers to the tribunal to hear and dispose of appeals against any direction, decision, or order of the authority under this Act. Since tribunal is provided with both the original and appellate powers, suitable appeal mechanism has also been provided for under section 18 of the Act. Whenever original power under 17a gets invoked, section 18.1 allows the central government or a state government or a local authority or any other person to make an application to the appellate tribunal for adjudication of that original dispute. However, for exercising the appellate powers under section 17b, the manner and mode is structured through section 18.2 to 18.4 of the Act. 18.2 allows the central government or state government or a local authority or any person aggrieved by direction, decision, or order made by the authority to prefer an appeal before the appellate tribunal. Section 18.3 obligates filing of an appeal within 30 days or any further period if sufficient cause is shown, and the appeal has to be filed in such form, verified in such manner, and be accompanied by such fees as may be prescribed. Section 18.4 provides for grant of opportunity of hearing before passing of orders. What is relevant is section 18.5, and the same is extracted below. The appellate tribunal shall send a copy of every order made by it to the parties to the dispute or the appeal and to the authority as the case may be. It is the case of the airport operators that the orders passed by the tribunal need to be communicated to three sets of parties, namely parties to the dispute, parties to the appeal, and to the authority. It was therefore submitted, since authority is specified independently and separately, they would not therefore fall under the first two categories, and the orders of the tribunal are communicated to the authority only for information, and consequently, the authority has no right to maintain an appeal before this Honorable Court under 31 of the Act. The submission needs to be rejected for the following reasons. A. 18.5 refers to three sets of parties, namely parties to the dispute or parties to the appeal and the authority, and more importantly, uses the expression as the case may be. The expression as the case may be evidences the fact that the tribunal is empowered to adjudicate original disputes under 17.8 as well as entertain appeal under 17b. When it hears the matter in exercise of its original power under 18.1, they relate to those issues in which ERA has no role to play, and ERA is never a part of the proceedings in any capacity, and consequently, ERA cannot be a party to the dispute under section 18.1. The expression parties to the dispute under 18.5 would not apply to ERA as it refers to such disputes arising under the original power under 18.1 read with section 17a. Since the authority cannot be a party to the dispute, section 18.5 directs the tribunal to send a copy of its order to the authority. However, when it comes to an appeal arising out of an order of an authority under 17b and filed under section 18.2 and 18.3, the authority will not be an appellant before the tribunal, as it can never be aggrieved by its own order, and therefore would not come within the expression any person aggrieved. However, for any reason the order of the authority is palpably wrong or vitiated, the central government under 18.2 can always prefer an appeal before the tribunal. Merely because the authority cannot be an appellant, it does not mean that the authority would not come within the expressions parties to the appeal under section 18.5. The authority would always be a contesting respondent under 18.2, and there is no statutory prohibition of exclusion to that effect. On the contrary, section 18.3 requires the appeals to be filed in such forms as may be prescribed. Section 51H, which provides the central government to make rules, envisages the framing of rules relating to the form and the manner in which form shall be verified and fee to be accompanied by the form under subsection 3 of 18. The Airport Economic Regulatory Authority Appellate Tribunal Rules 2010 provide the manner and mode of filing appeals in the requisite form. Rule 3.2 obligate an appeal against any direction, decision, or order made by the authority shall be filed before the tribunal in Form 2 and shall be in 5 copies and accompanied by the certified copy of the direction, decision, or order against which the appeal is filed. Serial number 3 and 4 of the form provides for entire details of the appellants and the respondents. It is extremely important to highlight that every airport operator or any other agreed person who had preferred appeals under 18.2 and 18.3 of the Act had consistently implemented only the authority as the respondent. An objection is raised by the operator that ERA is a quasi-judicial authority and therefore can never be a respondent and a party to an appeal. It is submitted that ERA is not a quasi-judicial authority. ERA is a regulator performing plurality of functions, which includes regulatory, inquisitorial, administrative, consultative, advisory, investigative, besides determination of tariff, even if it is called adjudicatory. Sale judgment is referred to, Mala. The distinction between a regulator and a quasi-judicial authority needs to be taken account of. Without prejudice, even assuming that ERA is a quasi-judicial authority, the embargo which applies to judicial forums like courts need not necessarily apply to quasi-judicial authority under all circumstances. Prior to the emergence of regulators in India, there were several authorities under the executive wing engaged in the exercise of quasi-judicial powers. Ideal to name one is the state and central tax authorities. A tax authority is part of the executive wing and is empowered to dispense quasi-judicial functions. The orders passed by such authorities are appealable by the contesting assessees, and it's a well-established practice to implead the quasi-judicial authority as a respondent before the respective tribunals. Notices of hearing is issued to them, and the tax department would represent its case before the tribunal. Therefore, there is no prohibition in a quasi-judicial authority being a respondent before the tribunal. In the light of the above, it is respectfully submitted that ERA as an authority has to be impleaded as a respondent whenever an appeal is preferred under 18.2 and 18.3, and ERA would always be a party to the appeal. Once ERA becomes a respondent before the tribunal, it has a right to maintain an appeal under 31 of the Act before this court. Section 31 reads as under. Reference, para 20. Reference was drawn by the operators to section 53T of the Competition Act, which reads as under. 21. It was contended that since there is a specific empowerment allowing the Commission to prefer an appeal before this Honorable Court under 53T of the Competition Act 2002, which is conspicuous by its absence in 31 of the Act, the authority has no locus standi to maintain an appeal before this Honorable Court. This submission needs to be rejected for the simple reason that the style of legislation under 53T of the Competition Act and Section 31 are distinct and class apart. 53T of the Competition Act identifies who can be an appellant before this Honorable Court and refers also to the Competition Commission. Under Section 31 of the Act, there is no such identification as to who is authorized to file and maintain an appeal before this Honorable Court. Section 31 only mandates that an appeal shall lie against any order not being an interlocutory order of the tribunal to the Supreme Court. It nowhere identifies who is entitled to be an appellant. Section 31 is wider in nature and permits filing of appeals against any order without limiting to the persons or entities who can file it, and consequentially, this submission should fail. Without prejudice to the above submissions, the issue as to the maintainability of an appeal by a regulator stands settled by the following decisions of this Honorable Court. In the case of Steel Authority of India, para 17 of the judgment records that SAIL preferred an appeal before the tribunal in which Competition Commission filed an application seeking impleadment and also for vacation of interim orders issued by the tribunal. By para 20, it referred to the order of the tribunal dated 15/2/2010 dismissing the impleadment petition by the tribunal, expressing the opinion that the Commission was neither a necessary nor a proper party in the appellate proceedings before the tribunal. Para 30 of the judgment formulated various points for determination, of which para 33 reads as under. Whether the Commission would be necessary or at least a proper party in the proceedings before the tribunal in an appeal preferred by the party. The question gets answered in para 31(3) of the judgment as follows. The Commission, in cases where the inquiry has been initiated by the Commission suo motu, shall be necessary party, and in all other cases, the Commission shall be a proper party in the proceedings before the Competition Tribunal. The presence of the Commission before the Tribunal would help in complete adjudication and effective and expeditious disposal of matters. Being an expert body, its views would be of appropriate assistance to the Tribunal. Thus, the Commission in the proceedings before the Tribunal would be necessary or a proper party as the case may be. From para 99 to 113, this Honorable Court proceeded to elaborate in detail on the expressions any person, proper party and necessary party. Para 104 conveys the ratio that absence of the Commission before the Tribunal will deprive it of presenting its views in the proceedings. Thus, it may not be able to effectively exercise its right of appeal in terms of 53 of the Act. Contention was raised, placing reliance on the same para to say that the body corporate has a legal right of representation under section 57O, which is conspicuous in its absence in the Act. The decisions rendered by this Honorable Court was not based on the provisions 53 alone. It is based on the effective right which the Commission has to exercise and how the Commission becomes a proper and necessary party in defined circumstances. This is vindicated if one would refer to the ratio in para 106, wherein this Honorable Court has held. It would not only help in expeditious disposal, but the Commission as an expert body, in any case, is entitled to participate in its proceedings in terms of Regulation 51. Thus, the assistance rendered by the Commission to the Tribunal could be useful in complete and effective adjudication of the issue before it. Again, by para 110 to 113, it brings out as a general proposition as to why a regulatory authority should be either a proper party or a necessary party before the tribunal. Another way to examine the matter is that if the proceedings cannot be concluded completely and effectively in absence of a party, that party should be normally implemented as a party before the court, of course, subject to other restrictions in law. While non-rejoinder of parties, necessary parties may prove fatal, the non-rejoinder of proper parties may not prove fatal to the proceedings, but would certainly adversely affect interest of justice and complete adjudication of the proceedings before the appropriate forum. As a normal rule, the applicant informant is dominus litis and has the right to control the proceedings, but at the same time, such applicant is required to notify all other parties against whom applicant wishes to proceed. Even if an applicant fails to join a party, the court has a discretion to direct joining of such parties, as the question of impleadment has to be decided on the touchstone of Order 1 Rule 10, which provides that a necessary or a proper party may be added. In the proceedings which are initiated by the Commission suo moto, it shall be dominus litis of such proceedings, while in other cases, the Commission, being a regulatory body, would be a proper party discharging inquisitorial, regulatory as well as adjudicatory functions, and its presence before the tribunal, particularly in the light of the above stated provisions, would be proper. The purpose is always to achieve complete, expeditious and effective adjudication. This court in Brahmadat, while considering the constitutional validity of Section 8 of the Act, observed that the Commission is an expert body which has been created in consonance with international practice. The court observed that it might be appropriate if two bodies are created for performing two kinds of functions, one advisory and regulatory, and other adjudicatory. Though the tribunal has been constituted by the Competition Act 2007, the Commission continues to perform both the functions stated by this court. In that case, cumulative effect of the above reason is that Commission would be a necessary and a proper party in the proceedings before the tribunal. The above judgment in no uncertain terms conveys the importance and indispensable presence of a regulatory authority before the tribunal. In the light of the above, in terms of 18.2, 18.3, 51, read with Rule 3.2 of the 2012 rules, Form 2 prescribed thereunder, ERA as an authority has to necessarily be a respondent and therefore a party in appeal in terms of 18.3. In Samir Agarwal, this court reads as follows. Clearly, therefore, given the context of the Act, in which CCI and NCLAT deal with practices which have an adverse effect on competition, in derogation of the interests of the consumers, it is clear that the Act vests in CCI and enables to act in rem in public interest. This would make it clear that the person aggrieved must, in the context of the Act, be understood widely and not be construed narrowly as done in Adi Feroz Shah Gandhi's, because Datta referred it this morning. For a regulator, this Adi Feroz Shah Gandhi judgment should not apply, is what this court has said. Para 34 refers extensively to the decision rendered in Said, and Para 23 reiterates that NCLAT, the tribunal, must be kept wide open in public interest so as to subserve the high public purpose of the Act. Reliance is placed on the 7-judge bench judgment in Bar Council versus Dabolkar, where a right of appeal to courts against an administrative or judicial decision is created by statute. The right is invariably confined to a person aggrieved or a person who claims to be aggrieved. The meaning of the words a person aggrieved may vary according to the context of the statute. One of the meaning is that a person will be held to be aggrieved by a decision if that decision is materially adverse to him. Normally, one is required to establish that one has been denied or deprived of something to which one is legally entitled in order to make one a person aggrieved. Again, a person is aggrieved if a legal burden is imposed on him. The meaning of the words a person aggrieved is sometimes given a restricted meaning in certain statutes which provides remedies for protection of private legal rights. The restricted meaning requires denial or deprivation of legal rights. A more liberal approach is required in the background of statutes which do not deal with property rights but deal with professional conduct and morality. The role of a bar counsel under the Advocates Act is comparable to the role of the guardian. I'll leave that paragraph. Number 30 onwards is important. If any decision of the disciplinary committee of the Bar Council of India is accordingly to the State Bar Council, such as will lower the standards and imperil the high traditions and values in the profession, the State Bar Council is an agreed person to safeguard the interests of the public, the interests of the profession, and the interests of the bar. The bar is not a private guild like that of the barbers, butchers, and the candlestick makers, but by a bold contrast, a public institution committed to public justice and pro bono public service. The Grant of monopoly license to practice law. I'll skip that also. Para 58. It is well-known case of Attorney General in the words person aggrieved or of wide import and should not be subjected to restrictive interpretation. They do not include, of course, a mere busybody who is interfering in things which do not concern him, but they do include a person who has genuine grievance because an order has been made which prejudicially affects his interest. Has the Attorney General a sufficient interest for this purpose? Their lordships think that he has. The Attorney General in a colony represents the crown as the guardian of public interest. It is his duty to bring before the judge any misconduct of a barrister or a solicitor which is of sufficient gravity to warrant disciplinary action. Then I'll skip para 59. In other words, certiorari is not confined by a narrow conception of locus standi. It contains elements of actio popularis. This is because it looks beyond the personal rights of an applicant. It is designed to keep the machinery of justice in proper working order by preventing inferior tribunals and public authorities from abusing their powers. The possible apprehension that widening, this is what was canvassed the whole morning today, the possible apprehension that widening legal standing with a public connotation may unloose a flood of litigation which may overwhelm the judges is misplaced, because public resort to court to suppress public mischief is a tribute to the justice system. In this very case, to grant an exclusionary windfall on the respondents is to cripple the Bar Council in its search for justice and assistance on standards. In Delhi International Airport versus ERA, even recently, this Honorable Court on 11/7/2022 had rendered a detailed judgment on tariff determination by ERA involving the dial as an appellant and ERA as a respondent. Para 7 of the judgment referred to the two sources of revenue, aeronautical and non-aeronautical, and how the former is regulated through a tariff regime. Para 9 explains in detail the algebraic formulation for calculating the targeted revenue involving complex formulas. Para 17 deals on the appeals from the regulatory authority, and the same reads as under. One may observe at this stage that in effect, this court has been made a court of second appeal in similar matters arising out of many such tribunals. This has resulted in a number of contentious matters requiring consideration by this court. The scenario is different from an SLP jurisdiction where no reappreciation of evidence is really required unless extraordinary circumstances exist, while an appeal of this nature stands on a different footing and is a continuation of the original proceedings. Para 33 to 37 records the submissions of the operators, while para 38 to 44 records the detailed submissions of ERA. The judgment is referred only to emphasize the fact that the ratio conveyed by this Honorable Court in 2010 through SAIL in highlighting the need and relevance for regulatory authorities to be either necessary or proper parties before courts and tribunals is found quite justified, and this Honorable Court entertained the appeal filed by DIAL impleading ERA as a respondent and delivered a detailed judgment on a very complex matter after taking on record the submissions of both DIAL and ERA, reiterating the position regulatory authorities can be necessary or proper parties and also can file and maintain appeals. Lastly, reliance is placed on the constitutional bench judgment of this Honorable Court in modern dental college. With the advent of globalization and liberalization, though the market economy is restored, at the same time, it is also felt that market economies should not exist in pure form. Some regulation of various industries is required rather than allowing self-regulation by market forces. This intervention through regulatory bodies, particularly in pricing, is considered necessary for the welfare of the society, and economists point out that such regulatory economy does not rob the character of a market economy, which still remains a market economy. Justification for regulatory bodies, even in such industries managed by private sector, lies in the welfare of the people. Regulatory measures are felt necessary to promote basic well-being for the individuals in need. It is because of this reason that we find regulatory bodies in all vital industries like insurance, electricity, power, telecommunication, etc. Thus, it is felt that in any welfare economy, even for private industries, there is a need for a regulatory body, and such regulatory framework for educational sector becomes all the more necessary. It would be more so when, unlike other industries, commercialization of education is not permitted as mandated by the Constitution of India, backed by various judgments of this court, to the effect that profiteering education is to be avoided. When regulatory bodies are vital in any welfare economy and meant to serve public interests, it cannot and should not be deprived of a right of appeal before this honorable court, nor being a respondent before the tribunal. ERA, being a custodian of public at large, is concerned with the outcome of the decision by TDSAT with respect to the price determination, among others, in its own interest and interest of general public. ERA, having mandated to determine the tariff, will have the jurisdiction and the right to challenge an order of the tribunal if its tariff fixation is interfered with. This locus flows from its responsibilities, obligations, and duties to ensure public interest and to protect the interest of passengers. If this power is read as being absent in 31 of the Act, possibly 31 itself would become redundant, since there would be no one who can be expected to challenge the decision of TDSAT, even if it is wrong. The final aspect that needs to be dealt with is the issue relating to bias. It was submitted by the operators that if ERA is made a party before the tribunal and also allowed to maintain appeal before this honorable court, the tribunal or this honorable court, wherever needed, may have to remand the matter back to ERA for redetermination. ERA cannot be both a contesting party and also redetermine tariff, and this will result in possible operation of bias. The submission is ill-founded. Institutional bias is not known to our jurisprudence. There are several instances where executive action may result in adverse civil consequences, and if these issues are challenged before the writ courts, and should high courts or this court quash those proceedings and remit it back to the same authority for redetermination, there is no embargo provided either in the Constitution or in any statutes or in administrative law jurisprudence for them to rehear the matter. An institution or authority is independent of its officers who act under such authority. Take the case of a show cause notice issued by an income tax officer or a GST officer which gets impugned in a writ petition. The said officer would be a respondent before the court, entitled to file counter affidavits, and should notice get squashed for reconsideration, the same officer in the capacity of an authority has to re-adjudicate the list. Consequently, the contention relating to institutional bias needs to be rejected. As a connected submission, it is once again reiterated, ERA is a regulator bestowed with plurality of functions and not a quasi-judicial authority as known to law. Even assuming without admitting that they are quasi-judicial, it is again not unknown to our jurisprudence that such authorities are employed as respondents either before a writ court or an appellate authority, including tribunals. An income tax officer would be represented by the department representatives in defending the assessments, and appellate orders are passed before the ITAT. Though the exercise of power and discretion is purely quasi-judicial in nature, it is a known practice that officers who had passed quasi-judicial orders would be permitted to make out their case before the tribunal and defend it. Consequently, this submission should also fail. Rest is all, Mullah, distinguishing the various judgments relied by them. In fact, Mullah, in one of the ITAT matters in November, Mullah, I've been asked to appear because Mr. Salve is appearing in this report, 7,000 crores. So we are appearing, defending the income taxes as Mullah adversarial proceedings. So Mullah, to say that a tribunal will not be an appellant or a respondent, but before the tribunal, any appellate authority will be Mullah an appealing authority. And 18.7, which Mr. Singh referred to, is a natural, it's a regular review power. Like any other possible.
Revisional power.
Yes, original review power. But just a few things we'll just submit, 4 or 5 things, Mullah, we'll close it today. Please see, Mullah, first thing to say, our status is now under challenge in today morning. They are saying we are not a regulator. Please for a minute see the statement of objects. And they say that we are not for public interest. These are the 2 important points, Mullah, Mr. Dattar and Mrs. Dr. Singhvi raised it. Please see the preamble. We are not a regulator and we don't act in public interest.
You never said that.
No, Mrs. No, one minute. Lord, Mr. Singhvi said there is no public interest involved. But I was at least actually listening. And Lord, to say that just a consistent case, Mr. Sajjan, everybody said we are not regulated.
Sorry,
please see, one minute.
The ruling says you must take into account passengers, airlines, and the passenger public. public interest or interest of the public. We're only concerned with passengers who use the airport.
Passengers, if not public, I don't understand.
Them.
To say that passengers are not, let me read what we have. The objective of creating us is this. I will read para 2 onwards. Statement of objects and reasons at page 37. My lord has it. Yes. At present, the airport authority performs the role of an airport operator as well as a regulator, which itself results in conflict of interest. This situation has often led to complaints of mismatch between the aeronautical charges levied by the airport authority and the quality of services rendered at airports which are controlled by airport authority. The Naresh Chandra Committee, set by the central government to prepare the roadmap for civil aviation sector, has recommended for setting up of an independent regulatory authority. In the above background, it is felt that an independent economic regulator, namely the Airport Economic Regulatory Authority, may be established so as to create a level playing field and foster healthy competition among all major ports, to encourage investments in airport facilities, to regulate tariff for aeronautical services, etc. It is therefore considered necessary to enact a law for the establishment of a regulatory authority to regulate tariff and other charges for aeronautical services rendered at airports, and to monitor performance standards of airports, and also to establish appellate tribunal to adjudicate disputes and dispose of appeals. And my lord, to say establish appellate tribunal to adjudicate disputes and dispose of appeals. Right. My lord, please see, I have two submissions to make in para 2 and 3. Para 1, para 2 and 3, at least, my lord, people who have created us certainly call us a regulator. And it will be too late to say that we are not a regulator. 1. And to say that, my lord, creating level playing field, fostering healthy competition, encouraging investments, and regulating tariff. For whom? For whom? For each one of the passengers. And if passenger, my lord, a sectional representation of a public, are we going to say that they are not public interest? Public interest means the whole citizens of the country should suffer. Every public interest litigation, I must show an underlying that the entire citizens of India are affected. Only then a public interest is maintainable. It's not so. A community or a group affected by it is also public. As long as, my lord, larger interest goes beyond, is, my lord, the essence of it. So therefore, my lord, and we are, please see 13.4, one of the powers of fixation of tariff, 13.1.4. Economic and viable operations of major airport is one of the conditions. For both, for the operator, for the passenger. Not today, earlier we were one of them. I believe the central government was running the airport. Today, my lord, it is either dial or mile or buy. Who are monopoly today? Can today, my lord, some flight which takes off from Bombay, can it choose to land in any other airport other than in dial? It has no choice. So when you substitute it again with a monopolistic practice, well, the regulator says you need, not judgment of modern dental, constitutional bench says you need a market regulator. And that's essentially the basis on which we have come into play. So, my lord, the first two submissions that we are not a regulator and we don't act in public interest, my lord, in our very respectful opinion, goes wrong. And therefore, these judgments will have an application. Then, my lord, please come to the second point. Lord, please see in this connection, the second point which your lordship may have to say is, my lord, please see 15. What are our functions? Section 15 allows us to issue directions in public interest. The authority may, for the purpose of discharge of its functions under this Act, issue from time to time to the service providers such directions as it may consider necessary. Lord, if your lordship sees under 17B, a direction is also appealable to TDSAT. So we do issue and they are filing appeals. And please come to 52, 51, 52. Lord, we have power to make regulations. So, Lord, it's a self-contained operating mechanism which is conceived by the Parliament. So, to say, my Lord, we don't have the trappings of. So this is point number one. Well, the second point, my lord, it was canvassed by Dr. Singhvi that advocates represent in the era. No, not at all. But three things don't happen in the process, like in a real adjudication, which happens in the Competition Commission. Not advocates don't appear. Affidavits and counter affidavits are not filed. Only a consultation process is taken. But the airport first comes. This is the process. The airport first comes with, my lord, a formula. The tariff determination authority looks into it and proposes a tentative, my lord, proposal. That tentative proposal, then the process of consultation gets initiated thereafter. And my lord, 13.4 uses the word consultation. Please, it never uses the word adjudication. Please come to my lord 13. There is no word expression, legal expression or statutory expression to say adjudication. 13.4 only says the authority shall ensure transparency while exercising its powers and discharging its functions inter alia, A, by holding due consultations with all stakeholders with the airport. B, by allowing all stakeholders to make submission. No affidavits, no counter affidavits, no adversary. This is not that type of an adjudication which my lord ERA is doing. So my lord, to say advocates appear, court fees are filed, that doesn't happen. Then my lord, third, my lord, it was oversimplified in a very respectful opinion today to say, after all, there are only 6 formulas. Then why all this litigation? Why should 18,000 crore become 45,000 crores? If they are only simple 6 formulas. And if you are going to only do six formulas, my lord, through the magic wand, and then we produce a result.
Referring to 45,000 crore prejudice the argument. It is 46,000 crores for a 5-year period, taking into account true up. I don't want to get into details. We can demonstrate the whole thing. And I'll give the ICAI thing that ultimately what they collect is only 6% of the total cost. So let him not keep on saying 18,000 crores to 46. I'll give the entire maths.
Well,
No. This constant thing, 9,000 crores, 10,000 crores, 15,000 crores.
At the end of it, I think your submission is that though you are not an appellant against an order passed by
a respondent,
because you are ERA, you are always a respondent. Because you would be implemented as a party, and as a respondent, when a further appeal is preferred under Section 31, you are entitled to file an appeal.
I'm a party to the appeal. That's the precise point.
You're a party to an appeal. No, he says that they are parties to the appeal which is filed under Section 18.
Yes.
And as a party in the sense, as a respondent, a proper party to the appeal which is filed under Section 18.
Yes.
He therefore has a right to file an appeal under 31.
Yeah, no.
That's the point.
Because in the matter which we argued in the Supreme Court, the only thing is, the difficulties, if ERA wants to justify, it says 46,000 crores. ERA wants to say it's only 25,000 crores. TDSAT says no. Now, can you say no? TDSAT also must have a right to justify its thing. My submission is both the adjudicator and the appellant do their job and they are out of it. Then the list is only between service providers.
Really, the point is that Section 13(1)(a) provides for the manner in which the tariff is to be determined by ERA. When the determination of tariff by ERA is the subject matter of an appeal under Section 18, ERA is a respondent because you would be called upon to justify the basis on which you have framed the tariff.
Every time.
Once we come to the conclusion that you are either necessary or at least a proper party to the appeal before TDSAT,
that's right.
Then once a decision is rendered by TDSAT, there is nothing to exclude your right to file an appeal to the Supreme Court.
It happens day in and day out in every executive function, my lord. It's not something so uncommon. Income tax officers don't they file appeal? Every day.
No, income tax.
Let me finish. Let me finish your counters first, and then you can speak, my lord. So, my lord. The last point is, sorry. Sorry.
But the Padiola was just saying that, there's a provision under which you can you have to determine the tariff once in 5 years, but within that period, you may amend it from time to time. Now, if the amendment within a period of 5 years is challenged by somebody, ERA, as a respondent to the appeal, would be in a position to justify what were the circumstances which led to the amendment. Suppose your amendment within 5 years is set aside, then surely you can come here according to you.
Otherwise, Mulad, it becomes But this is happening. It's not, we are not asking something for the first time. It's very, not differentiating a tribunal, a district court and a high court is distinct from a quasi-judicial authority. Even assuming, we are saying we are a regulator and we are doing.
We may not go as far, Mr. Venkatraman, to say that the determination of tariff is an administrative act. Because there are judgments of our court which say that tariff determination is partakes of a quasi-judicial function. Even so,
yes.
These are also hybrid, in that sense that, and therefore you are required to be, according to you, implemented as a respondent to the appeal which is done.
How can an assessment order be decided ex parte before an appellate?
Who will be the respondent?
Who will be the respondent? To say that somebody, it's a public money, treasury is public money, goes to the Consolidated Fund of India, so anybody can step in and argue a case against. Well, they have engaged me now in one case in IT-80 involving 7,000 crores. Somebody is appearing. So it's public money, 7,000 crores involved. Hey, public can go and file. They can. Why should an ASGB argue? All this can't work. We have to have a proper list, a proper adjudication process. It's too late in the day to say that we can't be a party respondent in an appeal.
Should we close it now?
Yes, please. Deeply obliged.
Only one request, Manoj. I just wanted to, my colleague wanted to point out that out of 46,000 crores, 45% directly goes to the airport authorities of the government.
Oh, 45,000 goes to the airport.
45% goes to diversion by overriding title.
How much? 45%.
45%. And in Bombay, it's 52%.
But this is they get the contract because of that bid. Don't make me a party.
Under your bidding document or what?
Yeah. It's bidding document.
So you will in your bid you will specify the revenue share.
Yes, revenue share.
When I go to my P&L account, 100 rupees of target revenue. I only show.
Mr. Datta, in a lighter way, we thought you would finish the matter on merits also by hearing both sides. You have taken so much time to argue the locus.
We'll just take it up.
For the first time, ERA preferred appeal. Past, they never preferred appeal.
Oh, no. No. Yes,
one more thing.
There has a
Just to
respondent.
say that 46,000 airport authority, which was not making money earlier, now because of Delhi, Bombay, Bangalore, for every 100 rupees, I straight away have to part with 42 rupees or 38 rupees, 45 rupees directly.
Airport authority.
And it's not an expenditure, it's diversion by overriding title. It doesn't form part of my income. It's directly to go to the.
My friends need not make me a party to the crime. We have to still fight the case.
And the last point to clarify on the tribunal issue, on income tax, for the appeal to the tribunal, the appeal.
It is only interpretation. There's no absence of
See, the real nub, the real dispute arose because 31 is silent on who can file.
That's why.
Now, there were two ways we said. One, you say that only those people who can file an appeal under 18 should be able to file an appeal under 31. But what we really have to consider is this, that if they are proper parties to the appeal under 18, can we then preclude them from filing an appeal under 31? So, 31 is silent on who can file an appeal.
Then the point.
Had 31 said the central government, the state government, or local authority may file an appeal, then it was out. They were out then. 31 is completely silent.
Therefore, Dhabolkar comes in, then ERA and all the arguments, he has not once demonstrated. If it is changed from 46,000 crores to say 39,000 crores, how is ERA affected? If it's reduced, I will come on appeal. If it is made, yes.
This is exactly the contradiction. Yes. They say, no, you are in public interest. They say, no, you are not in public interest. But this is in public interest. I have a role to play in ensuring the regulation is proper. How can they overlook that perspective and that statutory work which I need to perform in the larger interest of the passengers? My friend can't go hot and cold. He can't say public interest and also say not public interest.
I never said that. it doesn't, it sounds very unfortunate that the adjudicating authority criticizes tribunal judgment saying non-application of mine, travesty of justice. Very, very unfortunate.
That is something we'll tell our
Brother Mishra, since you were communicating today across the video conferencing, anything else that we have left? Any loose end that we need to tie up? So should we close it for judgment, brother?
Yes, yes.
Milords, may I, Milords?
The main appeal.
How long will you people take on the main appeal? Tell us that. I mean, then we can decide, whether.
Milords,
what's the.
Milords, may I make my submission, Milords?
So, the meetings are complete. Milords, it can be heard. Milords, it's not a very
the
short,
contours are
not
laid
a very
down
long point. It's a very short issue.
Two separate judgments.
Yes.
We'll deliver the judgment on maintainability.
Yes.
Once we deliver judgment on maintainability, you people tell us how long you will take on the merits. Then we can see what is the time. Another thing I was just reflecting when I was reading it over the weekend. Is it possible for all of you? They are appealed by Bangalore, Delhi, and Mumbai. Right. Now, is it possible to identify the issues on merits?
Yes.
Is it possible to identify the issues on merits and then tell us broadly which are the issues which are common to all the airports, which are the separate issues, say, for Bangalore, Delhi, and Mumbai?
Catalog and give it.
No, may I suggest?
Then, on the day when we deliver judgment, we hope it won't take very long.
Yes.
You can then tell us what's the time frame for hearing of judgment. You can hear it, we'll decide it. Otherwise,
No, may I suggest it's a section 100 issue, so we can frame the substantial questions of law in the matters.
We will agree at least.
That's not a bad idea, actually. That's very good.
It's not first appeal.
Yes. So maybe if you can all exchange between yourself
and frame
the proposed issues, you can just say arguments have been heard on the preliminary issue as to whether an appeal against an order passed by the TDSAT in the exercise of its appellate jurisdiction under Section 18 of the Airports Economic Regulatory Act can be maintained at the behest of ERA. Full stop. The judgment is reserved. Parties have filed their written submissions. Full stop. Arguments are concluded. Judgment is reserved. Full stop. At this stage, it has been agreed between the parties that without prejudice to the respective submissions on the issue of maintainability, all the parties would exchange proposed questions, substantial questions of law within the meaning of Section 100 of the Code of Civil Procedure 1908, which may arise on merits, having due regard to the provisions of Section 31. Section 31 of the Act. Full stop. This exercise shall be completed within a period of one week.
1 week
from the date of this one.
Your Lordship wants nodal counsel on each side so they can get everything. And
actually,
time limit.
If you can just
Mr. Milanka here, Maras, can be the nodal counsel, one person from there, and we'll put everything together. Lordship, give us a time.
So, just who are the two nodal counsel?
Milanka Chaudhary is here.
Chaudhary and Mr.
Nothing, Ms. Shweta Bharati.
No,
Ritesh.
On behalf of the Federation of Indian Airlines,
I know, Mr. Venkataraman.
From Ritesh Kumar.
Yes. Mr. Ritesh Kumar are nominated as nodal counsel to prepare a common compilation of documents and precedents in terms of the circular of the registry dated so and so. The common compilation duly indexed shall be filed within a period of 2 weeks. 1 week. Finish it in 1 week. Because everything is on the record.
Milords, may I only submit, Milords?
Yes,
I'm appealing for respondent number 4 in the appeal, ERA appeal, Milords. And on the last date, my lordships had asked me to file my written submissions. Milords, I have filed my written submissions and emailed them yesterday. Milords, I just want to draw my lordships.
What are you appearing for, Ms. Bathor?
Lufthansa German Airlines, Milords.
As part of the airlines.
One of the
group.
airlines.
My lords, may I just make two submissions? Submission one is, my lords, the TRAI Act under Section 18
Now,
provides
we'll
for
read
a
your
page of
submission,
this.
not the arguments are concluded. We'll read your submission.
Because I was muted, so I could not make my
No,
submission.
we'll read the submission, no difficulty. We'll read
Grateful manners, grateful manners.
Learned AG has also filed a 2-page submission notice.
So on the day when we list it for judgment, you can be ready with this so that we'll see what time frame, etc.
We'll get further.
Thank you. Thank you very much.
Please.
Venkatraman, do you want your voice to have a break?
No.
You are in the next matter also.
Yes. It's start tomorrow morning, no?
We're still at the airport now.
Same here.
Should we start tomorrow? I can start. Can I start? Briefly.
I have a note here on.
Yes, we have a note.
So we'll start first tomorrow morning.
We have circulated a note.
I hope you're not going to take very long.
No.
It's a short matter because we have a background to the matter also.
Yes. We hope to complete it tomorrow.
Tomorrow? You mean the whole of tomorrow?
From our end, not for me.
It just needs the interpretation of your own lordship's order.
Our own order. What is the consequence of their non-deposit and non-compliance?
And also
their contention is that the non-deposit would entail that the appeal would be heard.
Yes.
And which the appeal has been heard. You are saying that, well, non-deposit means you are not capable of reviving.
Liquidation.
That is one of the five
That's
issues.
it. That's all.
Because now the final order is passed.
Yeah.
One of the 5 issues, all that will take only.
No, these are concurrent findings. There's no substantial question.
Your lordship knows.
But you have a note?
Yes, we have a note and we'll go by that and we'll show very few documents. So convincing, my lord.
Do you have a list of dates?
Yes.
So we can
finish. But we will not take much time.
Let's wrap it up in the first session tomorrow. We'll complete it by lunch.
For us also, lordship, just 10 minutes. Yes.
You are supporting the.
So lordships will hear that workmen also. Just 10 minutes, I'll address it all. Because there's a reflection in the impugned order about that aspect as well. So we'll just about the workmen.
So there is one matter of West Bengal employees.
That
wanted to dispose of with this.
Where all those things about electronic evidence, etc. Question is whether we can distinguish between the tainted and the untainted. That matter, right?
Yes, that is the one question. That is the one. And second is whether the 65B evidence has actually
same matter.
Yes, same matter.
All right. We'll start with Jet tomorrow because Brother Mishra is also returning to work. I mean, he wasn't at work, but tomorrow he'll be on the dais with us. So we'll start with Jet. After Jet, what is the next matter after that?
Well, there's that
restitution
environment matters, those 2 benches.
Those 2. That
can be reconciled in 5 minutes if I just show you.
All, no?
Yes.
Who is appearing?
That's 295, 296.
Which solicitors appearing in that?
Government, Mr. Devedi.
Well, there are some amicus in it, to be fair. Guru is.
Don't think that will take very long, right?
That won't. It's actually a narrow issue unless your lordships are going in detail into the content. If you have to reconcile between the fact that it's 2 subject matters and 2 benches, we just have to show you to the extent of that overlap where it should be reconciled. That's really, I think, the way it would be best resolved.
And what is the way forward? Because now
it's way forward.
The destruction of the trees took place.
They are restoring. They're in the process of restoring.
Anyway, we won't discuss it since Solicitor is not here.
I just joined.
Yes.
My apologies, my lord. I just joined.
Right. Tomorrow, right after Jet, we will start the Ridge matter.
I'm in Ridge matter, my lords.
Yes. So right after Jet gets over tomorrow, we'll start the Ridge. After Ridge, I believe we have the challenge to the validity of the restitution of conjugal rights program.
But there we have to file our reply.
Doing all these commercial matters.
There we have to file our reply, my lords. We will file it, my lord.
Yeah. Solicitor, there more than that, if you just give us a note of your submission, that because what the reply only would be a written submission.
No, my lord,
We would like to, my lord, file our reply.
No, solicitor is talking about the Ridge matter.
No, no, I'm not in Ridge matter, my lord.
he's not in Ridge matter.
I'm not in Ridge matter.
Delhi government and DDA, those are the.
Yes, I am not appearing, my lord. I am requesting marital rape may be kept, my lord, on some other day, my lord. Tomorrow and day after, I have some difficulty.
So tomorrow we are starting with Jet and then followed by Ridge.
Ridge matter, my lord. But, my lord, this may not be taken up this week, my lord, the marital rape. That's the request, my lord.
But 300. The Muslims have been granted the parity and broad.
Then the West Bengal, that's on board. All right.
That
we'll go seriatim because we'll then finish one matter.
that school service commissions matter. 360. Can I
Yes,
come
but-
day after tomorrow? Then can I?
You're going to go back and come back.
No, I'll be here for other purpose. Or I can go back and go and come.
I think you're safe for tomorrow at least because these matters will take through tomorrow, I think.
I think in fairness, I must tell your lordships, I think you've listed Byju's also tomorrow. So,
Byju's is tomorrow with solicitors there.
Yes.
Because may I make one
That will not take very long, I think about
Because in the
Point is very short.
Plus, may I make one sub? Plus, in the Delhi Ridge matter, I appear for the contractor. So notice of contempt has gone to him and they're present. So should they be present tomorrow as well? They filed their affidavit.
but I'm for the contempt petitioner, their appearance can be dispensed. If
We'll say that
I don't think,
Anupam Lalda, Learned Senior Counsel, submits that in pursuance of the contempt notice, the contractors are present before this court.
And
From
they filed their affidavits.
Learned Counsel fairly submits that their further presence may be dispensed with. The personal presence of the contractors is dispensed with.
Same order for the principal secretary environment matters. We have filed our affidavit.
Is he here?
Well, he's here. The principal secretary.
He was required to be here. He'll dispense with the personal presence of the principal secretary.
Environment and Forest Delhi.
Environment and Forest, Delhi government is also dispensed with.
Much of that.
Deeply.
Vice chairman was already dispensed.
He's right.
Deeply.
Thank you, brother.
Right.
See you tomorrow.